client and the pre-sentence report as well. I don't know if you had a chance to look at that.
You did do that, she signed that one.
Okay, I'm just eager to get going on something this morning, but I want you to take a second to look at the documents that she needs to sign. And but you're my first and only case ready, so it'll be quick. Okay.
We may have seen these already.
There's the waiver of recusal form she needs to sign, and I think I put the two on top that she needs to go over and sign.
On this, Lisa, do you know? Who's here for MNSM Trucking? You have to start your video, please. Crystal Marie Holt, 25W838-286. Good morning.
There we go.
Okay, wait 1 second, sir. I'll be right with you.
Yes.
Good morning, Mr. Hyder.
Good morning, Your Honor. Mark Hyder, appearing on behalf of Crystal Holt.
Ma'am, your name, please?
Crystal Marie Holt.
So I need to inquire, is Kurt Patras here? Or anybody from Whitewater Car Wash, Habura Johnson, anybody here from that establishment?
No, not on Zoom, Judge.
All right, and we scheduled this for 8:30, right?
Correct.
For some reason, they have Mr. Hyder's name on here, Stephen Hyder from Monroe. So I don't know if you saw that.
Yeah, I just saw it.
I'll change that on the report. All right. Have you had a chance to review the report with your client? And are there any material additions, corrections, or deletions?
Your Honor, we have, and there aren't any material corrections.
All right. Anything that you would like to say on her behalf?
Your Honor, I would just indicate that based on what I see in the report, she was very frank with the report writer. She's been very frank and honest with me. From the day I met her, she's a hardworking individual, a very respectful citizen. This is a bump in the road that I hope that she will never do again, and I'm confident that she won't. I think the recommendations are reasonable under the under the circumstances, and I have every confidence that she'll complete whatever conditions you set.
All right. Ma'am, is there anything you would like to say?
Yes, Your Honor, I would like to apologize for my actions and behaviors, and it won't happen again.
Okay. The only thing that concerns me here, did you show your lawyer the AA verification?
She did.
And she's been going 3 times a week?
Yes.
Okay. The only thing concerns me here is this was really high, right? You know what I mean? It's a first offense. I'm gonna look at it like that, but boy, that's a high. Can't
I
be.
think you might remember that it was like she was at the casino and she hit a jackpot. You know that never really happens. So I think she went overboard.
Jeez, listen to me. I'm snorting up here and everything after hearing you say that. 12 months probation. You cannot leave the state without the consent of the court. You could leave the state for employment purposes without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number up, you must notify the probation department. You have to report as directed, okay? No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those, or marijuana. You're to submit to chemical testing, PBTs and ETGs. I'm gonna make it bi-weekly for 4 months. If you're clean, I'll make it, I'll revert it to monthly. And if you're clean after four more, I should say, then on demand. You are eligible for early discharge after half the time, so long as there are no violations within the preceding 90 days. So if you get everything done here, you can complete that. I'm sorry, you can apply for early discharge. So AA 3 times a week, victims impact panel. You only have to go to AA, NA until you're in intensive outpatient treatment. I'm going to order intensive outpatient treatment. You have to go to that. You have to attend AA, NA 3 times a week. But once you get into treatment, you don't have to attend AA or NA any longer. And you do have to go in person to AA, NA, okay?
Okay.
I'm going to order 4 days jail credit, 1 served 3. I am going to have you do one of those on the court work program. There's a $35 a day charge for that. And 2 days of community service. 2 days community service. I'm going to give you until, say, September the 10th to complete that. So you have to do 16 hours community service, 1 day on the court work program. This was a blood draw, so I give $225 in cost of recovery. So it's 300 fines, 300 costs, $75 victims' rights fee, $50 justice assessment, 7 1/4. Probation fees are $240 for 965. Cost of recovery is 2 1/4, bringing your total to $1190 plus the screening fee and the court work program fee. Everything included is $1285. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. I am going to order that you stay away from that car wash. Is there another car wash you can go to?
Yes, I haven't been back here.
Okay, so I'm going to order that you not go near 20981 West Road. Okay, so you can't enter that property address at 20981 West Road. And no contact with employees of that business, okay?
Okay.
All right. Do you have any questions?
What is work?
Court work program, 1 day. You're going to work on our court work program. Probably should be 3 days, to be honest with you. But since it's a first offense, I'm going to do this, okay?
Thank you, Judge.
Can she pay this or does she need time?
I need time.
Okay, do you have anything today?
I think she's pretty tapped out right now, Judge.
Okay, you tell me what you can afford to pay, ma'am. You make $950 a week. Can you pay $125 a week or not?
Yes.
You get paid weekly?
Bi-weekly,
I'll tell you what, I'll make it 200 bi-weekly. Can you do that?
yes,
When do you get paid next?
next Friday.
So that would be on the, let's see, the first. So I'm just gonna make all your payments due on a Monday. So you pay $200 bi-weekly beginning August 4th. If you don't have the money, no problem. Call the court on or before the due date. We'll go on Zoom. I don't care how many times we have to do it. Or you come in here if that's easier. I'll be glad to give you an extension, okay? I don't care how many times we have to do it. Just don't ignore me, okay? You'll meet with probation before you leave. Nice to see you, Mr. Hyder.
Always
Take care. Thank you very much. All right, MS, yeah.
Can I just verify the fines and cost amount, just those two numbers?
I'm sorry. I hope I
think I
didn't
missed
screw
it.
something up. That's
Oh, no,
usually
I
a
missed
sign. That's usually a sign I screwed something up. I got 300 fines, 300 costs, 75 victims' rights fee, $50 justice assessment. That's 7 1/4. Screening fees, 60 for 785. I have probation fees of 240, bringing the total to 1,025 plus cost of recovery is 225, bringing the total to 1,250 plus 35. Is that wrong?
No, you're right. I just missed one number. You're good.
Okay, no problem. Thanks, guys. Thank you.
Thank you.
All right, SM Trucking, 25W839049. Where'd he go now? Amanda Sierra, 25W839111. Stay right there, sir. Your name?
Amanda.
Amanda what?
Amanda Serrato.
Your charge, it's SIERRA, correct?
SIERRA.
Okay, nice and loud for me, okay? You're charged with drive over while unlicensed, and you have the right to a lawyer. If you want one, I'll give you one. Do you want one?
No.
All right, the police think you were operating a motor vehicle on Western Gudith in Woodhaven on June 24th, 25 at 6:04 p.m. They think you drove while unlicensed. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs or all those. Do you understand that? Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes.
I can't hear you.
Yes.
All right. You have the right to a lawyer. Do you still wish to waive your right to a lawyer?
I'll take a lawyer.
I'm enter a not guilty plea, $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes.
All right, good luck. Thank you. You're going to go meet with the lawyer, and either way, you're coming back in front of me. MNSM Trucking, 25W83949. Your name?
Milan Milivojevic.
What is your position with MNSM Trucking?
I'm owner of the company and also I'm driver on that time. I drive that truck.
So this is a corporation and you're the principal, the president. Is that true?
That's the truth.
All right. So listen, I'm going to let this go. Usually you're going to need a lawyer on these. Okay. I'm going to let it go here. You work this out. It's a fine line. I'll let you go ahead and since you're the principal and your last name spelled Milivojevic, correct?
Yeah, that's correct. That's my last name.
All right.
Mili.
And besides that, you could not show up and I'm going to charge you. They charged you with impeding traffic or pleading to impeding traffic, right?
Yeah.
To that charge, responsible or not responsible?
I'm sorry. I didn't get.
Responsible or not responsible to impeding traffic?
Yeah, I'm responsible. Yeah.
I'll accept the plea. He cut you a break. He warned you on another one. $235 is your fines. Can you pay that today?
Yeah. The only reason because I actually joined that Zoom and try to if any chance if he can lower that charge.
Yeah. He impeding traffic's about as low as you can go. I mean, it's 0 points.
Okay, yeah, I can pay today.
Okay, thanks a lot. Have a good day. Good luck to you.
How I gonna pay that? You guys going to send me the fine home on my
Would you-
home address?
Lisa, would you chat with him and tell him, please?
Yeah, watch your messages, sir.
She's gonna message you. Thank you. Ryan, Chloe.
Yeah, my question is, I mean,
What?
He thinks he's talking to me. I'm messaging him.
Okay, Ryan Michael Coloyan, 25WA38905. A and B, your name?
Brian Coy.
You're going to plead to impeding traffic. You're gonna dismiss the no insurance and suspend, right? Right?
Yes,
To that charge of impeding traffic, responsible or not responsible?
responsible.
Did a good job for yourself. Maybe you should be a lawyer. All right, you're not licensed. You gotta get licensed, okay?
Yeah, I'm gonna go do that.
You're 34 years old, right?
Yeah.
Come on, get licensed. You ever been licensed?
No, yeah, I have one. It's just, it was out of state.
I see. So when you moved here, you didn't get it?
Right.
You didn't go to the Secretary of State. All right, $250 is your total. You can go down the hall and pay that, all right?
Yep.
Best of luck. And by the way, I'm dismissing both the no insurance and the suspend pursuant to stipulation. Good luck.
Thank you.
Hamilton. Heather Margaret Hamilton, 24WA34257. Ma'am, your name?
Heather Margaret Hamilton.
All right, you did everything it looks like, right? Raise your right hand. Solemnly swear or affirm on the penalty of perjury the testimony you'll give in these proceedings will be the whole true self you got.
Sorry.
You solemnly swear to tell the
I
truth?
solemnly swear to tell the truth, yes, sir.
All right. Since you were in court in front of me, when I sentenced you on the date and placed you on probation, that was August 7th of 24. Have you been arrested since then?
I have not, sir.
Any new charges?
No, sir.
Any contact with the police?
No, sir.
Congratulations, you're all set.
Thank you.
Prosecutor moves to dismiss, case dismissed. Good luck. Thank you. Guy Neely, Jacob Eugene Dwayne. Guy Neely, 25B148494, A and B. Your name?
Jacob Eugene Dwayne G. Neely Jr.
How you doing?
Uh,
Not too bad. Who filled these out? Who was doing this, Lisa, July 2nd for me?
I have to look that up. Hold on.
Oh, this was Judge Green.
Yes, I couldn't remember her name. Yes.
Okay. You said you told the judge you weren't going to pay it anyway?
That was me. He told that too. I tried to set him on a payment plan and he wasn't cooperating. So I told him to talk to you next time he's in.
Did you tell her you weren't going to pay it anyway?
no, that ain't what happened. She asked me what.
She's not going to lie to me. She lies to me. She's going to be, look, she's going to be salt and fries at the local.
I wasn't paying nothing. It's not what I said.
What'd you say?
She asked me, what could I pay? I gave her a number that was too low for her. and
What
she
was the
said
number too low?
30. She asked me, what could I?
Hang
pay
on,
her?
slow down. You're not going to get an attitude with me, are you?
I don't have to.
Well, just slow down.
She's not lying.
You told her $30 how often you could pay that.
She just asked, what could I pay right now? I told her 30. She said, that's too low, so just wait until he come back from vacation and be a talk to him. That's what she said. I never in life told her I wouldn't.
You wanted to pay 30 a month?
No, she asked, what could I pay right now? That's
Well,
all
I'm
I
going to
had.
read you what she said.
Okay.
Okay? Judge Green advised defendant to see leasing for payment plan. Defendant has 4 other cases with balances. Defendant asked for 30 a month. I told him the minimum I could do was 50 a month. He said I could put whatever I wanted because he wasn't paying it anyway. Defendant has new cases on July 9 with MKM, meaning me. Advised he could talk to the judge on July 9 about a global payment plan. Where do you work at? Why not?
I'd be having to watch my kids sometimes.
Do you have a wife? She's just the mother of your children? Yes?
Yes.
Where does she work?
In Detroit at a, I think at like a food place.
Okay. Let's you and me start over. Okay? Now you can tell me, you're gonna have to get a job. These are your responsibilities here. You understand what I'm saying to you?
Yes.
So nobody told you to go out and commit a crime. You did it. There's consequences to it. And you're gonna tell me now, you're gonna give me a reasonable, but we're not a bank here. You understand what I'm telling you? We are not a bank. You look like an able-bodied man. You are what, 22 years old? Yes?
Yes.
Did you graduate?
I'm in school.
Where at?
E-course high school. E-course alternative.
So you make sure you're gonna get your GED, right?
Yes.
We're not that hard to get along with here. Okay?
Yes.
We really aren't. I don't like when people go down and not paying it anyway. A judge ordered you to pay this amount. You're gonna pay this amount. I don't care if you agree with it, disagree with it. You pled guilty. Nobody forced you to plead guilty. And here's where you are.
I'll pay that. I just only had $30 on me at that moment.
She was talking about a monthly plan. How much do you have today?
Nothing, but I can pay before I leave. Like I don't have no money on me, but I can go pay before I walk.
I don't know what that means. If you don't have any money, what are you gonna do? Go to the ATM?
No, tap pay. Tap in my phone.
Okay. With a credit card
Yeah,
or a debit card.
yes.
You gotta tell me how much you can pay though today.
Oh, like 100?
All right. So you owe $325 on the suspend. And what is this, 200 on the other case, Lisa?
Yeah, he's got 5 outstanding tickets and then 4 pending cases. You should have a pending case up there today for drove while suspended.
All right, listen. I'll let you pay $100 on this false information charge today. Now, that will leave you with $325 on the other case, plus you'll have a $100 balance on this case. Now, tell me when you can pay these.
Okay, 100 today. I can pay the 100 on this case. Another day,
So tell me,
the next day so the day after tomorrow.
after tomorrow is Friday. You're telling me you can pay another 100 by Friday?
Yes.
Okay. All right. So I'll set you up on that. You pay 100 now and the balance by July 25th. Now you got a 300. I'm just going to go ahead and dismiss the show causes, by the way. I think. Is there a show cause on this? Yes, there's a show cause. So on 494A, I'm going to dismiss the show cause. Okay, so now you owe 325 on the B file. You tell me now when you can pay that.
And Judge, just so you know, there's 4 other tickets with balances.
I know.
I can roll them all together if you want. I just.
Well, I think given how it went down, I think I'm going to set the payment plan on this one. Has he been show caused on the others?
Let me check. No, not yet.
Are they assigned to me?
Let me see. Yes,
Can you send them all down?
yes.
All right, I'm gonna have her send the rest of those down. And in the meantime, we'll talk about when you can pay this 3 1/4. Okay? So you tell me when you can pay this. What if I set you up on $50 a week? Can you do that?
Yes,
Starting when?
next week, Monday.
You mean like 5 days from now? You pay 50 per week on that charge. I'll give you another week, okay? I'm gonna give you until August the 4th. Can you pay 50 a week on these?
That's 3 tickets you give me? Or,
On the false info, you're paying $100 today, 100 this Friday. Right?
Yeah.
We're done with that then. I'm gonna set you up on a payment plan of $50 a week. Do you think you can handle that?
yes,
Okay, if you can't handle it, you call the court, we'll go on Zoom, I'll work with you. So I'm gonna have her print out, Lisa, I'm sorry, I'm just gonna have you print out, set it up. We'll start with the 50 a week on this one and then 50 a week on the other ones until paid. So she'll give you a printout. If you don't have the money, there's no reason to be scared. All you have to do is come in here and talk to me or call the court, say I need to Zoom in with the judge on or before any one of your due dates. Things happen in life, right? Our air conditioning goes out, engine goes out, whatever. We get an unexpected bill. I don't have any problem with giving you a multitude of extensions. Just don't ignore me. You know what I'm saying? If you come to me every week and say, Judge, I can't pay that much. Can I have another week? I'll do it. We with one another?
yes.
Okay. So that's what I'll do, and she'll give you a printout on the other ones, okay? I wish you well. Good luck.
Judge,
Yeah.
he has Woodhaven cases today.
You have Woodhaven cases today too.
He needs to be arraigned on those.
So you need to be, do you have those, John? This is Mr. Guy Neely. So I'll arraign you on those, okay? David Lee Martin Jr., have we called the police on this? We need to call the police on this.
I
Somebody
did. They're on Zoom.
Okay, perfect. David Lee Martin Jr., 25G 701798. Come on up to the podium, sir. State your name.
David Martin Jr.
Carmen.
Morning, Your Honor. Michael A. Carmen, P7324, on behalf of the defendant.
Good morning, detective. Your name?
Good morning, Gary Robinson, Gibraltar Police Department.
All right. I want you to call in Emily, please. I signed a warrant on this case back on May the 29th. In all honesty, I wasn't putting 2 and 2 together, I don't think, at the time. Geez. So at any rate, he's in my sobriety court. What do? Does he stand mute, waive formal reading?
Yes, Your Honor.
I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. You have the right to a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that question. Do you understand that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. You'll be in front of Judge Hessen. That will be on August the 5th at 9. Preliminary exam, August the 12th at 11. At the preliminary exam, the people have to show the crime was committed, the felony crime of OWI 3, and that you were the one who probably committed it. If they prove that, you'll be bound over for further proceedings. If they fail to prove that, the case will be dismissed and you'll be discharged, at least as to that count. Do you understand that?
Yes.
So again, probable cause conference, August 5th at 9, preliminary exam, August 12th at 11. Ms. Tessino, your name?
Tessino?
Mr. Carmen, what would you like to say regarding bond?
Your Honor, just want the court to consider that my client is employed full-time at Aspen Tree, makes about $800 a week, does not have any dependents that he supports, and does live alone. He's And actually, Your Honor, this offense is from January 2024, so, it's been hanging out there for a while. But, he's here today, has not missed any court dates, no previous felonies whatsoever, so would ask for consideration of a virtual bond, in addition to the typical no alcohol conditions.
Do you know why it took so long, Detective, for somebody to bring this to us? It looks like the warrant was authorized back in January of 24.
Yes, Your Honor. We had, I think it was 6 cases that were uploaded improperly by the Wayne County prosecutor. I had, I think, 2 of them already in your courtroom. We just weren't made aware of it, and the court case in Carpel was not updated. And then once a manual search was done for his name, that revealed that there was a warrant pending from the Wayne County prosecutor. I've been in touch with the prosecutor for future uploads, and all of our cases have been searched manually now for the last 4 months to make sure that there's no other missing ones.
So I want to talk about bond conditions right now. You're off the sober link, right?
Yes, sir.
He can apply to have that. Let me think through this please. I wonder if they're going to give him a sobriety court case on this one. I mean, reduction. I don't know if they will or not. I need him back on the sober link, though. I cannot in good conscience. I know he's doing well.
Could we do the 3 times a week testing and save him a little bit of money, or would you prefer the sober? Like, he's doing twice a week right now, chemically testing.
Yeah, because I can't.
Because he did 120 days on the sober link at the start.
Yeah, because I can't pass that cost on through our grant if it's on a new case.
Correct. He would be eligible, I would assume, for the discount, John, but it's still, it only saves him $1 a day on the sober link.
He's doing good by all accounts, I want everybody to know. In our sobriety court. $10,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume those. I want you going to AA, NA 3 times a week. You're not to possess firearms. You're not to possess dangerous weapons. You do have to test 3 times weekly. Chemical, PBTs, ETGs. That's what I'll do. You'll be in front of Judge Hessen August 5th at 9, August 12th at 11 for the exam. Anything else? Did I miss anything? Anything else, Mr. Carmen?
No, sir, thank you.
Thank you very much. Good luck, Mr. Martin. Keep doing what you're doing. Thanks, Detective.
Thank you, Your Honor.
Thanks a lot. People against Gene Ely. Jacob Eugene Dwayne Gene Ely, 25W8389038 and B. Your name?
Jacob Eugene Dwayne Ely Jr.
So charged with false information and dry while suspended. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
Yes.
All right, we'll set you up with a lawyer. The lawyer can go talk to the prosecutor on this, okay? Listen, you can't drive if you don't have a valid license. Okay? You get yourself in all kinds of trouble here. I don't know why you're suspended. Talk to your lawyer about that. I really didn't look. Talk to your lawyer about that, what you can do to go get a license, okay? Good luck. Anything else ready down there? Nothing? Stay seated, everybody. As soon as I get something, I'll be out, all right? Thanks.
Two cases are called 40897 and 40898, the state of Texas versus Kenneth Jackson. Is that you? Present with your attorney and the state's attorney. Mr. Burbank, on behalf of the defense, we're here for what purpose?
Bond reduction,
All right, go ahead, summarize what it is you feel like the defendant deserves under the law.
He has been incarcerated for almost 4 years.
Why is that? Why is that?
And I've been his like second attorney. But we have announced ready judge, just as this past Monday.
When are we ready for trial? When are we for that one? Are y'all ready?
Said yeah, for Monday.
We're ready.
It is Mr. Eckhart's case, and
Is this the one that we were going to prioritize, right?
Yes,
For next week?
I believe it was one of the ones we were going to prioritize.
All right. It's set for next week, right?
is it?
When is it set?
It was set this
It
week.
was set this past Monday.
It did not get reached.
And
We'll roll it over. When's our next trial setting?
we have
Or
a special setting next week.
after that?
Uh,
What's the first one after?
With you, Tom,
With you,
Christopher Keller, he specially sent that 2 weeks ago.
same way. Jimmy Abbott.
What after that?
August the 11th is our next docket, a trial docket after which one?
That one's going for sure next week. That you're actually set on?
Date's ready on that one, yes.
I'm always ready, Judge.
And on the 11th, Mr. Burbank has a murder case with me that's over 1,000 days old.
How old is this one?
I mean, as Your Honor knows, we're doing our best to whittle those down. I just want to.
You know, we're doing our best up here too. I think we're all doing our best. It's just the 22nd largest county with the 16th highest crime rate in the state.
Yes, Your Honor.
We need more courtrooms, courthouses. I don't know what you do about that, but it needs to get tried as soon as possible. So on the 11th, August 11th, he's asking, can we put that in? Tom?
Judge,
We could, Judge. I mean, it's just, if the one on the 11th doesn't want to plea, I mean, that's going to have to take priority. But this one's been sitting for 4 years or more.
Yeah, it's.
How about the docket after the 11th?
Well, I don't know what it is.
For 18th, specially set in Hardin County on a 10-year-old sexual assault case. And he's been sitting in jail. He's been in there. I can be ready then if he pleads, but he's told me he wants a trial.
Okay. Yeah, we can plan that way, whatever they say, and then whatever happens, but this, what do y'all have to say?
We're asking that the bond be reduced down to 50,000 on each case, Judge.
I don't want to do that. I want to try the case. When can we try this case? Put it in August 11th. I'm substituting it. Can we do that?
Judge, I will gladly step aside if that's the case you want to try.
All right, that's what we're going to do. Set it for August 11th. How long do you think it would take to try?
It'd be less than a week.
Okay.
Right.
Then he'll be one, and the other one will be two, if that happens to.
I think it's one and the same incident date. I mean,
No, he's talking about your other case.
oh, the other, that's Cody Owen. The co-defendant has already been sentenced to, what was it, 40 years, Jim?
Chelsea Ship received 40 years. Cody Arnold is the co-defendant on that. And Judge, even though you're placing this on there, I'll be ready to go on that case. If something happens on this,
it's going to be set for trial August 11th. And that's what we shall do. 3 weeks. Is that right? 3 weeks. How's Mr. Cumberford coming along? David, you've got some things we got to get into a murder trial here in 20 minutes on your, you've got a Keeler Maldonado. Keeler Maldonado. That's an announcement. What are we going to do? I guess we're ready.
Yes, sir. Well, that's what I was thinking.
Is Keeler Maldonado is in custody?
No, he's not on.
Keeler, come on up.
Sorry, Judge, if I could.
Come on up, sir. No, I'll do it. I'll take care of it.
I'll go back and talk. Yeah, just let me know.
All right, as you know, sir, you were indicted December of last year for the first degree felony of aggravated robbery. You're looking at up to life in prison. You know that. All right.
When we were here last on June 19th, Judge, my notes reflect the defense was given 1 week to discuss a cap offer of 12 years.
Okay. Well, what happened on that?
Well, it's been excessively more than 1 week, so they should have an answer for us.
What's the answer on that? Are we going to dispose of it that way?
Judge,
Do we
because
set it for trial?
Because there's been that much time, if I could have about 3 minutes, you want to take the 12 years?
It's a cap. It's a cap.
Well, but you would take the.
Does he, you know what that means? Talk to him.
We talked about it too.
Well, let him ask, in the meantime, he may have come up with some other questions. Talk to, I give y'all about 5 minutes, okay? And
yes, sir.
Give me a final answer. Okay, thank you. And then John West is where? We don't know. He's got 3 cases. Thank you. Appreciate him. You know.
Stop fighting.
Yeah.
You got moved to Wednesday because Tom the master one.
Yours. Well, I'm sure we covered it.
Oh,
She's already been arguing with Bernie a bunch anyway, so she's already in the loop.
oh, yeah. It's my favorite. Well, he didn't remember what I was saying.
Yeah, trying to remember our case. Brand new, really right now.
But we should haul around.
Dennis, John's outside. West, would you be so kind to invite him in? Thank you. And the big question on each of these is saying, we start with Chelsea Clark.
Stop right there. We're still working on that.
Rod Serling is going to walk in any minute. You got 3 cases there, John. We got a trial. We got to get Murray back to what. And the big question on each of these is saying, we start with Chelsea Clark.
Stop right there. We're still working on that if we can
It's a
get it.
DWI, my God.
I know.
Christ that.
I know it's there's some. Yeah, there's issues, but I can't cover with you. So.
Well, I know, but what's the, well, who am I? I'm just a judge, but is it financial related stuff?
No, it's about conviction versus way to keep it off from if possible, and we're trying to see if that we can make it something to that. The problem is you can't do it further than you have a child. And
Funny how that law is. I mean, it was
I know.
legislature did it for.
You've asked, and it's saying that it's straight probation.
No, I mean, if we're not gonna have any possible way of doing it, then.
Well, there were 2 children involved. The state did not charge her with 2 offenses.
Yes.
What were you going to say next?
Oh, then I guess we have to go to trial.
All right, where's, then that's Chelsea Clark, come forward. Chelsea Clark.
Second.
Oh, reset.
Look on this probable cause on this case. What was the blood result? Because all I.
0.189.
Oh. Okay, so twice the legal limit. Okay, what are we gonna do? Final, one way or the other? We're gonna go one way or the other. It's time. This was indicted in December of last year. 7 months have gone by.
Yes.
What are we gonna do?
Let's set it for the trial.
Let's set for trial, period, in the ballgame. That's what we're gonna do. Special set that as soon as we can. Okay. We'll get, that's the way it is. There is no deal. We just let a jury decide. Okay. What's on Clark and Charles Johnson?
Mr. Johnson's right there. Mr. Johnson, come up.
What are we doing on this one?
This one is a trial for sure. There's no negotiating this.
Do you still live on Crow Road?
Yes, sir.
Okay. It's 4235.
Yes, sir.
How long have you lived there?
August or September, like 3 years.
Okay. You're a Beaumont resident? You grew up in Beaumont?
Yes, sir.
Okay. What's your criminal history on this? I don't, there isn't anything on the indictment of criminal history.
Priors, but all the same there.
Anything is enhanceable?
I have 2 state jail felony convictions that I'm looking at, so that means he's not eligible for probation from the jury.
But it's
not enhancement.
What are the prior convictions for?
Judge, they are for possession of controlled substance back in 2006, as well as another possession charge in 2009.
Yeah. Okay. I'm reading it.
Not over it.
Okay. The complainant in this case, do you know the complainant in this case, Nisha? Okay, you can't have any contact with her, you know that. Okay, all right, because I know, we all know what happens all the time. And we catch people all the time. They do things they're not supposed to do. And then the complainant victim in this case feels guilty about the whole thing, which is all backwards. That's not the way it's supposed to be. I don't want any influence on this person. She according to his probable cause affidavit, went through hours of torture. And the jury ought to know this. You're not eligible for probation. You're looking at up to 20 years in prison. Do you understand? We're going to try this.
Yes.
And if I find out that she is reluctant because anything you did, I'll your bond will be revoked and you can sit this out in jail until we get around to it. Have y'all talked to him?
This is Mr. Boyd's case, Judge.
Somebody ought to do that because
Yes, sir.
I sense I sense a whiff of an issue here
Yes, sir.
that we know what doesn't put up with. It's trying to influence the process illegally. Let me just catch it and deal with it severely. I'd like her. I want to know what her input is for y'all with y'all right now on where it is, and that he hadn't tried to influence her or contact her. No.
Yes, sir.
Because we'll have him up here and then he'll be put away until we can get around the plans.
Yes, sir.
Get a resetting for trial. Felder Williams, please.
So there's no come right back to that one. So that's one who's just now found competent. So not just yes, oh, you're you don't have to I don't know if we need to bring him out and rule that he's competent now, but this is something we just gotta report that saying he's competent. The facility barrels back. So
Felder Williams, please. Felder Williams, 23 CR 1723. Thank you.
May I proceed, Judge?
What's up?
You will be a plea in the case that I have in hand.
When?
Well, as soon as I get him signed up.
Okay, I got a jury coming in 5 minutes, but try to see what you can do.
Yes, sir.
We'll squeeze it. So do we have some fires there? Yeah. So what does this do? Let's. A lawful parent of the weapon on 2006. After that became final, committed to felony robbery 7. You are Felder Williams.
Yes, sir.
In cause number 23 CR 1723, Mr. West, John West here is your attorney, correct?
Yes, sir.
As you know, you are charged with the indictment of evading arrest or detention with a motor vehicle. It's a 3rd-degree felony, which means you face up to 10 years in prison. However, you have some prior convictions here. You have an unlawfully carrying a weapon charged on a licensed premise out of this court in January of 2006. That's before I was a judge here. And you were convicted after that became final. You committed the felony of robbery of a second degree felony and were convicted of that in June of 2007 in the court next door. So if all of this is true and correct, you are what we call a habitual felon, which means if convicted of this 3rd-degree felony, and if all of these other prior convictions are true in the indictment, you're looking at a minimum of 25 years in prison up to life in prison. Do you understand what you're facing? Do you understand what you're facing?
Yes, sir.
Okay, serious. You can life in prison. And that's, as you know, if you commit offenses and you keep committing offenses, the punishment gets higher and it gets more severe. Now, based upon concerns to the court about the defendant's competency, the court ordered that an evaluation be done. It was sent to the University of Texas Health Science Center at Houston.
Put her down pretty bad.
Was admitted to the facility in January of this year. And as he was found incompetent to stand trial. And the court has received a report dated July 16th, 2025, which consists of 8 pages. And have the parties had an opportunity to review that report of the analysis of this defendant? It's actually consists of cover page 8 pages of a report, as well as an attending physician's report of 3 pages. And then, so that makes, approximately 13 pages? 12 pages, fully, of the report. And we're going to call that Reports Exhibit 1 today. If the parties had an opportunity to review it, any corrections or changes or additions to it?
I reviewed this on Friday, Your Honor. Yes, I have no additions or changes.
I'm reviewing it now, Judge. I don't see any objections, no changes.
It is, hey, Jimmy, I got a gift for y'all.
Thanks, Judge. We're always playing.
The problem is it's the same color.
Yes, sir.
As
I didn't know what they was telling about.
That's the you're different now than you were then. That's why we're here right now. Okay.
Oh, they still in the low office on the phone.
Right now, the officers do. I'll talk to you in a second.
Oh,
Thanks.
all right, that package is referred to as Courts Exhibit Number 1. It will be made a part of the record for all purposes. Does anyone wish to add anything to this? No?
Not from the
State or defense? All right, the analysis is that the court has received this and the defendant is deemed competent to stand trial upon this evaluation. And it will be set for trial. And do you understand, again, sir, you are looking at a sentence if convicted of this indictment. What's in this indictment? No less than 25, no more than years in prison, up to life imprisonment. And also, yeah, this is not an aggravated case. But that when you're looking at life in prison, that is not the most important concern. All right. Where are we on this?
We have an offer, but now that Mr. Williams is competent and can actually communicate with us, if we get a little more time, I can probably get this resolved.
How much time do you need? I mean, I think he's been thinking about it. I mean, we're talking,
well, I would say set it for 3 weeks, since I'll be out the next 2 weeks.
What is?
10 years is the offer. And he's at 25 left. Yeah. And I want to talk to him a second. I can change his mind. Let's do it today. We'll do it today.
What do you want to do? Have you thought about it? Have you had the chance to think about it? I'm asking you, did you know about the offer? No. Okay, you get a chance to think about it.
Yeah.
You have a fair,
yes, sir.
You have a fair opportunity to think about it. How much time do you think y'all need?
Well, like I said, Your Honor, I'm gonna be on vacation for the next 2 weeks. So if we can get that week I get back, which is the 11th, things will be fine with me.
Except for the 11th.
Okay.
Of
August.
Okay.
I'm leaving on vacation on Friday.
All right. You can make a decision by then, one way or the other, and then we'll live by it. We'll go one direction or the other. Okay?
Yes.
All right. Work with him. He's a good man. All right. So that case is reset. What else, John? I spelled. Oh, yes, sir.
I believe.
Yeah. Mr. Coleman? And then David's working on something, isn't he?
Yes, sir.
That Jan could already.
Well, we now call 24 CR 1887, the state of Texas versus Dustin Coleman. You are Mr. Coleman. And you are here with your attorney, Mr. Comerford. Where is your office?
Austin.
In Austin? No. Spent some wonderful years there, postgraduate work, and yeah, beautiful city. Spent a lot of time in the hill country. Boy, they've had some terrible things with the water.
Very sad.
You know, a place near there, and it was nice to get some water, but not over.
Yeah, too much.
No overreaching. The Pedernales, I couldn't get over the Pedernales that weekend. It was a raging, a raging torrent. It was terrible, but could have been worse. But they need water, and just I'd like it in a fair sequence, not overwhelming. Sure. Okay, in 24 CR 1887, does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes.
In summary, sir, this indictment, as you know, alleges that on or about June 23rd, 2024, in Jefferson County, Texas, you committed the state jail felony of criminal mischief. Do you understand what you were charged with here, sir? What's this?
We're pleading to a Class A misdemeanor, Your Honor, the lesser included.
You too?
Yes.
We are. Okay, as you know, state jail felony, if convicted, means you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Now, the lesser included offense is what?
It's the same thing. It's just the amount would be more than $750, but less than $2,500.
And what's the plan? For what's the disposition?
2 years deferred probation on the Class A misdemeanor.
And restitution?
Yes.
Is in how much?
$2,560.
Is that it?
Yes.
Yes.
Okay. An agreement has been stand by. Has been made where you will be pleading guilty to the lesser included Class A misdemeanor of criminal mischief, which is it less than 2,500?
Yeah, it's more than 750, but
More
less
than,
than.
okay, I won't do that. Everybody has problems writing on this pad. I'm going to write it in English.
It's worse for lefties.
That's your excuse.
Yes.
I've only been one since birth, and I know what you mean. All right. You were facing again up to 1 year in jail and or up to a $4,000 fine. That's what's normal for a Class A misdemeanor. Is that your understanding of the plan you will be pleading guilty to in this criminal mischief, lesser included offense?
Yes, sir.
And you would be placed on deferred or unadjudicated probation for up to 2 years, ordered to pay restitution in the amount of $2,560.18 to the complainant in this case as indicted. And there would be other terms and conditions of probation which are normal and customary for this type of case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case, sir. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor under this state jail felony indicted case of criminal mischief? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes,
I'll
sir.
show you what's marked as State's Exhibit 1. Did you sign that document? Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged or, most importantly, any lesser included offenses, such as the one you were pleading guilty to, that the parties have agreed to resolve this matter in that way. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. This court finds this is true according to you, so help you God. Correct?
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports, Wayne.
Yes.
I'm going to follow this agreement, if nothing further, and find you are pleading guilty voluntarily, knowingly, intelligently. You are mentally competent to do so. There's enough evidence here supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation for 2 years or less. You do well, you can get it shortened. There will be terms and conditions of probation which are normal and customary for this type of offense, including you must pay restitution in the amount of $2,560.18, which goes to the complainant as alleged in the indictment in this case. And then there are other terms and conditions of probation, which are normal and customary for this type of offense. Please follow this. It'll pass fast enough. Then you can move on with your life without a criminal conviction. In this case, if you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in jail, which nobody wants in this case. Of course, you pay restitution back and we can dismiss it in a third. So you can do the math on 2 years. What's that? 24, 30, 24, it's 8 months. So, and I'm happy to do that if everybody agrees that's the right thing to do. Okay. Please see the probation officer. Thank you. Yes, sir. Take care. Thank you. Be careful.
Will do.
Then I've got David on Keeler Maldonado, right? All right, Dennis, please tell the jury that we're waiting on finalizing some other matters, and we ought to be ready, hopefully within 20 minutes or so. If they can relax, stretch your legs. Here, this, I better keep this.
But somebody we have not, we don't see him do one, so we now for us. It's
You look at that?
At the scene. Okay, so that's the on ceiling right there.
Oh, they travel.
All this is your speech. So,
Yeah.
oh, there is no thought of the things that all these are. This is the one. And the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about November 2nd, 2024 in Jefferson County, Texas, you committed the first degree felony of aggravated robbery. Do you understand, sir, what you were charged with here? If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. Also, in addition, a fine up to $10,000 can be assessed. Do you understand the punishment range you were facing here? An agreement has been reached where you would be pleading guilty and whatever sentence shall not exceed a cap of 12 years in prison. So we got some options here. This court, if I follow this agreement, you would be looking at no less than 5 nor more than 12 years confinement in prison. That's one out. And you can be placed on deferred or unadjudicated probation for up to 10 years in length where you are not found guilty. And you have to follow terms and conditions of probation. If you fail, your probation could be revoked. You could be then found guilty and sentenced. And then there is no regular probation for this type of offense. So if you're placed on deferred or unadjudicated probation, however, I think you're looking at the full range of punishment if your probation is revoked. And the cap of 12 years would not apply. So you'd be looking at all the way up to life imprisonment if you were placed on probation, then failed. And the circumstances showed that your probation should be revoked and then you would be found guilty, then you'd be looking at the full range of no less than 5 nor more than 99 years or up to life in prison. Do you understand this? Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand? Okay. Court can consider what?
I'd have that scenario, Judge. Put in there regular probation, but that is not a consideration before we might look at it with weapon. And Mr. Ham brought that to my attention.
Once I deciphered that handwriting.
Well, some of us learned over 3 years old, some of us are still trying to learn how to write.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes? Yes. Is that right? I show you what's marked as State's Exhibit 1. David, you need to sign the bottom of that, please, too. Here. There we go. You see your signature to that? And I'm going to ask you, did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct? Yes. State's Exhibit 1 tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You are guilty of the kind charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by the lawyer. Mr. Grove, all truths will have you out. States Exhibit 1 is made a part of the record for all purposes. We're going to order a pre-sentence report.
Yes, sir.
And we'll come back in August 29th of this year. And then all parties can add anything else we want, and then the court will make its decision. Okay. All right, good luck. Thank you. Please see that lady. Thank you. And then we'll send you to the probation office. Okay, that's all right, back on this, let's
Sudeep Singh Somal, 25W39129. Good morning, Mr. McDermott. How are you?
Good morning, Judge. Good, thank you. We do have a resolution. I have authority to plead to the amended charge of impeding traffic, request 2 weeks to pay.
All right, and I need your appearance. I'm sorry.
Sean McDermott, P46101, on behalf of Mr. Somal.
All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, I'll accept the plea, $200. I'll give until August the 7th, okay? Have a good day.
Yep, you as well, Judge. Good to see you.
You too. Bye now. All right, Sierra, Amanda Serrato, Sierra, 25W39111. Could I have seated up here Jacob D. Neely, right over here at the table, my right, your left, and Popovsky seated there as well.
Good morning, Judge. I'm here on behalf of Ms. Sierra.
Your name?
Amanda Sierra.
She's going to plead to impeding with the unlicensed to be this driver unlicensed to be dismissed. True?
Correct.
Have a seat, sir. You can have a seat right there. Right there at the table. All right. To that charge, impeding, responsible or not responsible?
Responsible.
Okay, I'm going to accept the plea. 250 is your total. And you are all set, and you can go down the hall and pay that, okay?
Thank you.
And you have that now, right?
Yes.
Good luck. Guy Neely, come on up to the podium, sir. Jacob Eugene, Dwayne, Guy Neely, 23W838903, A and B. Your name, sir?
Jacob Eugene, Dwayne,
Good morning, Judge. As I gave it to you.
Does he stand mute? Waive formal reading on each of these charges.
Yes.
Not guilty, pleas entered on the false ID as well as the suspend personal bond, $500. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to give you a new court date.
Judge, can we request 30 days? He's got-
Okay, 4 weeks, I'll give him, absolutely. He's got to take care of, he's got other cases, I guess, tomorrow.
Yes.
What do you have, Lisa?
August 20th at 8:30.
August 20th at 8:30. You need to fill out a petition for a court-appointed lawyer going forward, okay? So we'll have you fill that petition out before you leave. Maybe you can hand him one. You can sit down there, fill it out, and then you'll come back. Good luck. Thank you. Gabriel Christine Potts, 25W838818A. Is this yours or somebody else's?
That's not mine, Judge. No.
Who's your lawyer?
Crawford.
I thought we were going to get Mr. Crawford in here.
I called him, what's his number, Judge?
I don't know, does anybody not have Mr. Crawford in here that's got a case ready? Hello? Anybody? What's your name?
Noah. This problem on Mr. Walker.
Ma'am, have a seat right behind you, okay? Noah Ryan Lohr. 25, right there. There you go. 25W839130, A and B. Come on up to the podium, state your name.
Noah Ryan Moore.
You're charged with drive while license expired. You're also charged with no proof of insurance. You have the right to a lawyer. If you want one, I'll give you one.
I have insurance.
You want a lawyer? I can't hear you.
No.
I'll arraign you on my own, and then you can go talk to the prosecutor or tell me you want a lawyer. On June 27 and 25, it is alleged that you were operating a motor vehicle, or we're at, I should say, 22753 Allen Road in the city of Woodhaven, that you had an expired license. That's a misdemeanor punishable by up to 100 fines, 90 days jail, costs are all those in 2 points. And you also have the second charge and no proof of insurance. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You still wish to waive your right to a lawyer? I can't hear you. I'm entering a not guilty plea, $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes.
Go out in the hallway. He'll set you up with the prosecutor. You speak with him. If he doesn't give you what you want, you can come back and ask me for a lawyer.
Thank you.
Gabriel Christine Popovsky, 25W838818A.
Good morning, Your Honor. Michael Crawford, United Station Referral.
Gabrielle Kowalski.
All right, so your client pled no contest due to a lack of memory to this charge of disorderly person public intox. She was referred for a screening and assessment. Have you had the opportunity to review the report with her? I need it. And are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, Your Honor. There are no material additions or deletions that we're asking. Currently, she can't comply with the order, so we asked that there would be the recommendation be considered as an order.
Ma'am,
Yes,
is there anything you would like to tell me?
that will never happen again.
What in the world was going on that day?
Intoxication.
Yeah, I know, but it seemed to.
Well, Your Honor, my client had a lunch to drink. She doesn't remember that. She knows she had too much, and she had an interaction with a guy acting inappropriately outside of the restaurant. It led to this charge.
How old are you?
34.
You ever been in trouble before?
No.
All right, I'll go along primarily with this recommendation. 8 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm gonna order that you attend the Substances of Abuse Group through Class A Training Center as recommended. Okay?
Okay.
Now, I'm gonna have you test, I'm gonna have it monthly for 3 months. If you're clean, I'll then make it on demand. Okay?
Okay.
So chemical testing, submit the chemical test, PBTs and ETGs monthly for 3 months. If you're clean, I'll then make it on demand to probation. Okay?
Thank you.
1 day court work program, 2 days of community service by September 15th. There's 1 day on the court work program, which that's $35. You're gonna attend that, complete that. $100 fines, 100 costs, 75 victims' rights fee, $50 justice assessment. 3 1/4 probation fees are $160 for 485. You have a screening fee of $60 for 545, attorney fees of $40 and then $35 in court work program fees. Everything included amounts to $620. Give me 1 second here. They did not, there was no 771 or anything on this, was there? Okay, all right. So do you fully understand the sentence of the court, ma'am?
Yes, sir.
Do you have all of that to pay?
No, Your Honor, my client would like to propose a payment arrangement. What she can do, Your Honor, is pay $100 today, and then she'd like to pay $100 every 2 weeks, consistent with her pay period starting August the 8th.
All right, the other thing I want to indicate is you're not to go near 21,000 West Road in Woodhaven. Do you understand that, ma'am?
Yes.
And I will abide by that request for payment. So I'm going to have you pay $100 today and then $100 bi-weekly starting at August the 8th. If you need more time, come talk to me. Or if you're not in the area, call the court. You can either do it by Zoom, if you call the court and say, I need to talk to the judge about an extension, or if you're around here and you want to come in, you can do that instead. But it has to be on or before the due date, 8:30. Any questions? All right, you'll meet with probation, go down and pay your 100, then go across the hall to probation. Good luck. Robert Lewis, Thornton Jr., 25W837260.
Good morning, Your Honor. Mike Dill Crawford, representing the defendant, stands to my right. Sir, state your name, sir. Robert Lewis Thornton.
All right, so he pled guilty to resist and obstruct an officer. You got warrants all over the place.
Your
Have you
Honor,
reviewed the pre-sentence report with them, and are there any material additions, corrections, or deletions?
I have reviewed the report with my client. There are no material additions or deletions, Your Honor. We actually report accept the recommendation as presented.
You know, they talked about 771.1. That was agreed to for 12 months. Probation's recommending no probation. Does he want to take advantage of that and be placed on probation, or does he want me to adopt the recommendation of the court, of the probation department that says no probation, just court work and fines and costs?
Your Honor, give me 1 moment. Your Honor, my client would like to take advantage of the probation opportunity.
Okay. All right. What would you like to say, sir? Anything?
No, thank you, sir. I just appreciate the help. Your Honor, the court should know that my client has spent upwards of $500-600 addressing a lot of those warrants, and he's in the process of clearing it up. He knows he's got some work to do, but he started the work, Your Honor. And as he said, he's appreciative of this opportunity. He wants to protect his record. So the court can be as lenient as possible. He'd appreciate it. was a tough day that particular day. He was upset. He was being unreasonably uncooperative with the police. He understands that he won't do it again.
Anything else, sir?
That's all I'm saying.
I'll take this under section 771.1 for 12 months. You cannot leave the state without the consent of the court or violate any law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to clear all of your warrants by August the 25th. I expect all those to be cleared by August 25th. You're going to serve 1 day on the court work program and pay $35 for that. You're going to serve 1 day of community service by September 15th. So again, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I want you to stay out of trouble, okay?
Yes, sir.
I'll take it under 771.1, clear all warrants before August 25th, serve 1 day court work, 1 day community service by September 15th. You do all of that, and you also not to go near to, that's the Siegel Chiropractic Clinic, not to go near 21631 Allen Road in Woodhaven. I'm going to kind of go light on the fines. $100 fines, 50 costs, 75 victims' rights fee, $50 justice assessment, 40 in attorney fees. So your fines and costs are $315. Probation fees, well, you got to pay the screening fee of $60, and the court work program fee is of $35. So, let me see. $410. You do have probation fees of $160. Your total's $570. You pay that, you stay out of trouble. You do the court work, clear your warrants, do your community service. Again, stay out of trouble. Stay away from 21631 Allen Road in Woodhaven. I'll give you a review date. You pay your fines. I'll dismiss the case on motion to prosecutor. What do you have as a review date?
Was it 12 months, Judge?
Yes.
You charged.
They only do 160. I'll tell you what, I'm going to reduce them. I felt maybe that's why I did it subconsciously. I'll reduce your probation fees by $80, sir, to I'm going to reduce his probation fees from 240 to 160. But it's still 12 months, so
July 8th of 26 at 9 o'clock.
July 8th at 9 a.m., okay? Of 26, you'll have to come back for your review hearing and I'll dismiss it. Does he have all this to pay?
No, Your Honor, but we do have a payment plan to propose. He can pay $100 on July the 28th, and he can pay $100 per week thereafter.
$100 by July 28th, $100 weekly beginning August 4th. Can you do that?
Yes.
Okay. If you ever need more time, call the court. We'll go on Zoom or come talk to me on or before due date. I'll be glad to give you an extension, okay?
Yes, sir.
You'll meet with probation, you can go meet with probation now. Good luck to you. Thomas Patrick Abraham, 24W833-005B.
Good morning, Your Honor. Michael Crawford, representing Mr. Abraham, who's approaching. Please state your name for the record.
Thomas Abraham.
I don't even know what good it's going to do to put him through. He's had opportunities to get himself some help in the past. He just doesn't seem to do it.
Well, Your Honor, he's committed to follow through on things. He understands.
What are you still fooling around with this stuff for, sir?
I just made a few bad choices, Your Honor. I just want to, get it right now. That's all. I'm trying to close on a house, and I just want to, put this behind me.
I know, but you got to get yourself some help. You can't keep doing this. You just can't keep doing this. I mean, what am I supposed to do? He's had other opportunities. He said other opportunities to stay away from this stuff and to get himself some help. He's got a warrant out of Westland for a drug offense. He's had an impaired, an OWI, a drug charge, an order, allowing an intoxicated person to drive, armed robbery. He's on probation or parole for armed robbery. Did he get any time on that?
He did serve some time, yes.
How long?
64 days.
That's all?
Yes, sir.
Armed robbery is a life offense. I don't need to know the specifics. I trust. Good morning, Mr. Urick. Nice to see you. How are you?
It's a privilege to be seen, Your Honor.
Good to see you. Your name?
William Urick on behalf of the city of William.
All right. I don't know what to do with him. I'm going to be completely honest with you. I don't think you're going to comply with probation.
I would appreciate the chance, Your Honor.
All right. What do you want to do? Is there anything you'd like to say on his behalf?
You know, nothing other than the fact that, again, my client is really making renewed efforts to improve himself. Like you mentioned, he's trying to perk clothes on the house, which is around the corner, coming into this community, Your Honor. He realizes he's too old for this silliness. He's type of shenanigans can't keep going on, and he's trying to improve, the rest of the last years that he's got left. He doesn't want to keep being right up against Your Honor. Give him an opportunity. I think he's more earnest and serious about this time, Your Honor.
I came down.
Exactly. He faced up to this one.
Anything else you'd like to say? Either one of you?
No, Your Honor.
Sir?
No, Your Honor.
I'll tell you what, you didn't have anything to add on this, did you?
Your Honor.
You cannot, 15 months probation, they're recommending 18. I'm gonna see how he does. 15 months probation, you cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those things. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You declare all your warrants within 45 days. You are to attend an intensive outpatient treatment program at a facility approved by probation. You have to go to AANA at least 3 times a week until you're in intensive outpatient treatment. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. Clear all your warrants, as I said, within 45 days. I'm going to have you do 5 days of community service. 5 days of community service, that has to be completed. I'll give you all the way until October 1 to complete that. Fines $100, costs $225, $75 victims' rights fee, $50 justice assessment. So fines and costs here amount to $450, screening fees $60 for 510. You have $300 in probation fees. Everything included is $810 plus your attorney fees. Your total is $850. If you violate, your probation could be revoked. You could be jailed for 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, Your Honor.
All right. Can he pay all of this today, or does he need time?
Your Honor, my client needs time. We have a proposal. He's on a fixed income, Your Honor. He can pay $200 today, but the court knows he's taking this seriously. But all he can afford to pay is $100 a month.
That's okay. $200 today, $100 a month. We'll start that beginning August the 10th of every month thereafter. You'll meet with probation. Good luck. Thank you. Rogers. Wayne Michael Rogers, 25W8388658A and B.
Good morning, Your Honor. Michael Crawford, representing the defendant, to my right. So state your name, please.
Wayne Michael Rogers.
So he's going to plead to allowing an unlicensed driver to drive. And we are going to then dismiss the equipment violation and suspend on motion of the prosecutor. True?
That's true, Your Honor.
If you do that, sir, the possible penalties are up to 500 fines, 90 days jail, costs are all those. If you plead to that, and I'm talking about allowing unlicensed driver to drive, I'm then going to dismiss the equipment violation and suspend. Do you understand that?
Yes, I understand.
And did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
I understand.
To the charge allowing an unlicensed driver to drive, how do you plead? How do you plead?
Guilty?
You sound like you're asking a question. Do you want to plead guilty?
No,
You don't want
Not
to plead guilty? Pardon?
not guilty.
You want to plead not guilty? You want to go to trial on the suspended
No,
equipment?
I don't.
Well, what do you want to do? I mean,
I'll plead guilty then.
slow
I
down.
understand.
Hang on a second. Let's just slow down. Maybe I'm going too fast. Do you want to talk to your lawyer further?
Yeah.
Have a seat right there. Thank you. Jose Luis Silva Murillo, 25W8390918 and B and C. Your name, sir?
Sir.
Your name?
Jose Luis Silva.
Can you understand me well? You understand English?
Sorry, sir, I don't speak English.
Let's get an interpreter on this one, Lisa. You don't have I saw another interpreter walking around here today. We don't have one today on him, do we, Lisa?
I don't believe it was him. Let me double check.
Yeah, this is his first appearance. I'm gonna get you a Spanish interpreter. I'm gonna have you come back.
Okay.
I know it's hard for me to communicate when we're gonna get you an interpreter. Interpreter. Do you understand me?
Yeah.
So we'll get him an interpreter. We'll reschedule that. I'll let you go down the hall and my judicial clerk will give you a new date. Okay?
So,
All right. And then we'll see you back here. Okay? Best of luck. Wayne Michael Rogers. Did they go out? Okay, good enough. Alexandra Wolf, 25W839121. Where's Ms. Wolf at? Is she not here? She's on Zoom.
She's coming in right now.
Ms. Wolf, can you start your video and tell me your name, please?
Alexandra Wolf.
Okay. You're charged with parental responsibility violation. Do you want a lawyer?
No.
It's alleged that you violated parental responsibility law by allowing your unaccompanied juvenile daughter to take a bus from Pennsylvania to Michigan, where the juvenile had no support or supervision. It does not indicate how old the child was. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea. I'm going to indicate that you stand mute. I'm going to give you a $500 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to send you to talk to the prosecutor. We're going to put you in a breakout room, and as soon as the prosecutor is ready, he will speak to you, okay?
Okay.
So you just wait in there for now, right?
Okay. Thank you.
I wish you well. Good luck.
Thank you very much.
Either way, you're coming back in front of me today, okay?
Okay.
Thanks. People against Dwayne Johnson. Dwayne Montiel Malik Johnson, 25W838-974, A, B, and C. Mr. Johnson, come on up here and tell me your name.
Dwayne Johnson.
You're charged with driving on a suspended, speeding, and no proof of insurance. You have the right to a lawyer. If you want one, I'll give you one.
Yes.
Okay? We'll send you to a lawyer. Okay?
Okay.
And then you'll speak to the lawyer and you'll come back in front of me. Okay?
Okay.
Thank you.
Thank you.
Barton. Kelly Lynn Barton, 23R513-503. Ms. Barton, you can come up here and tell me your name. You're back again.
Yeah, I didn't know I had one.
You're charged with failure to refrain from consuming alcohol or drugs, testing positive for amphetamines on a chemical test of May the 19th of 25. That is a misdemeanor. I'm sorry. That's a violation of probation. You have, or they think you had a violation of probation. That's 6. You have 6 prior technical violations. You could have your probation revoked on this. You could be jailed for 93 days. Do you understand that? Did you sign an advice?
She was a walk-in, so I think she should have the arraignment attorney.
Yeah, I'm going to give her one right now.
She should have already spoke to him. She was a walk-in.
Did you speak to a lawyer?
I spoke to somebody in that room over there. I don't know.
Oh, okay. All right. Do you know who you spoke to, though?
Yeah.
Well, was it a man or?
Yeah, it was a man.
Well, you'll recognize him, right?
Yeah.
Okay, so we
Tony
need,
Carmen today.
we need you to go find him, and then I'll go ahead and give him that.
Okay.
Okay? Thank you. McCullers, Brandon Keith McCullers, 16F2222, 85A, Andy. McCullers, your name? Your name?
Brandon McCullers.
To what do we owe this honor and privilege?
I'm walking in on a warrant. I'm trying to clear up.
How was the warrant? How was the warrant?
There are a few of them. I think the oldest one is 2016.
Yeah, right. That's what I have. Where you been?
Yeah,
You've been fighting in a war somewhere overseas? I mean, what have you been doing? 9 years, seriously?
No, Your Honor. At the time, I was working at Flat Rock Assembly Plant. I went through a divorce after that time and went through.
Let me get you a lawyer right now, okay?
I did speak with the gentleman, I believe that's the arraignment lawyer, if I'm not mistaken.
What do you look like?
It's Mr. Carmen.
All right, let's get Mr. Carmen in here on this one as well. Have a seat. I'll be right back with you, okay?
Yes, sir.
So I need Mr. Carmen. I need Tony Carmen on Barton and McCullers. Carmen on Barton and McCullers. What's your name, ma'am?
Me, Michelle Sinani.
What, you have her on docket?
I do. She's a.
What? All right, let's go on McCullers. Brandon Keith McCullers. 16F2222, 85A and B. Mr. Carmen, your name?
Michael A. Carmen, 7324 on behalf of the defendant.
Name, sir?
Brandon McCullers.
What are we doing on this?
I believe this is a couple different, two.
He's got a driving on a suspended and he's got a possession of a controlled substance charge. These emanate from a December 3 of 16 incident.
He's gonna stand here with the formal reading.
I hope he's got some money with him. I really do. Where do you work?
Currently I work at Pratt and Whitney in Lansing, Michigan.
Well, I hope you got some money. If not, you're gonna be sitting in jail. You can't do this, okay? You can't come to pretrial, schedule it for bench, and then not show up for 9 years. If there's some judge somewhere somehow that thinks that this is okay, I hope you find them when you play this little game next time. 4,000, 10%. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. I hope you have the money. I truly do. Do you have the money?
Yes, Your Honor.
You come here tomorrow, July the 24th at 9:45. If you miss tomorrow, next time I will set the bond at 100,000 and I'm gonna set it way down the road. You got it?
Yes, Your Honor.
Your Honor, that's on both cases, correct?
Correct. I'm only setting 4,000, 10%, and that's on the A file. Go down, post the bond. Do not leave this building without posting the bond. Good luck. Barton, Kelly Lynn Barton, 23R 513503. He's gonna need to fill out a petition for one too, for a court appointed, Lisa. Your name, ma'am?
Michael Lee Carmen, 37324, on behalf of the
All right. How's she going to proceed?
Can she will plead guilty, and then just I'll give an explanation of what my client indicates that.
I'm gonna need Jessica in here. Will you call her, please? If you plead guilty here, I want you to understand this is this would be your seventh technical violation. You could get 93 days in jail with credit for any time served. You understand that? Did you sign an advice of rights form today? You're presumed innocent. They have to prove you guilty by preponderance. You have the right to question their witnesses, to bring in your own, to use the subpoena powers to court to bring in those witnesses. You have the right at a trial to testify or remain silent, or at a hearing. If you remain silent, that silence would not be held against you. Do you understand that? If you plead guilty, you're giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes,
The charge that you fail to refrain from consuming alcohol or drugs, testing positive for amphetamines on a chemical test on May 19 of 25. How do you plead? I'm sorry? Did you consume amphetamines?
Not only that.
Did you consume amphetamines?
I took my daughter's medication by accident. I did not know I consumed any of it, except my medication, I thought.
I'm just asking you, did you consume amphetamines?
Unfortunately, yes. Like the worst day ever.
You're not gonna tell me you didn't knowingly consume amphetamines, are you?
Yeah, I did. I had no idea about it. I'm bipolar. She has ADHD. We don't keep.
How old is she?
She's gonna be 14 next month.
Where does she keep her medication at?
She usually keeps them in the bathroom. She was happening to go to her friend's house for Comic-Con that weekend, so she brought everything in the treasure.
What did you think you were taking?
I thought I was taking my Paxil.
What were the other drugs she's been using? Wasn't some of these, I don't know, I'm gonna check.
Positive for amphetamines in the past and methamphetamines. She's
Yeah, I mean, I don't
positive for
know.
alcohol.
Anybody forced you to plead guilty?
No.
You consume those, you consume those intentionally though, correct? I understand you're trying to tell me, hang on, please. Hang on, please. You consumed drugs. I know you're telling me that you thought they were your daughters, right?
No, I thought they were mine.
I'm sorry. You thought they were yours.
I have anxiety, sir. I
Ma'am.
don't take anything like that. I have a very, very bad anxiety. I don't take anything like that. It would be the worst thing I could take. I went to work that day. I didn't know what I had taken.
All right. Has anybody forced you to plead guilty?
No.
How many times has she pled guilty to consuming meth or amphetamines?
Including this time, I would say this is the third time.
So what were the other two?
Well, let's see, she pled guilty on April 1st for amphetamines. She pled guilty on June 10th of 2024 for amphetamines. She pled guilty July of 24 for amphetamines. September 12th of 24, she pled guilty for alcohol. Alcohol again in November of 24, and then alcohol in the most recent one, which was March 13th of 25, Your Honor.
I have a problem with alcohol. I don't,
We got a problem with other drugs too.
no, I don't do drugs. I never have been a drug addict.
Did I mishear you? Say that again. Anything relating to the drugs?
We have tested positive for violations for amphetamines on April 1st of 24, June 10th of 24, July 16th of 24, and then the most recent one, Your Honor. So that's 4 times, I believe.
I can't remember what happened in those.
Wait a minute. Did you accidentally take the amphetamines on those days?
I do vaguely recall an excuse on one of her other violations regarding taking something she didn't believe was that. I can't recall specifically if that was it, but it does sound like a familiar story I've heard before from a violation with Kelly in the past.
At a minimum, you're responsible for not ingesting or consuming something that you cannot consume. Okay? That you're ordered not to consume.
I haven't been taking any medications at all because this can't happen.
Man. Then why'd you take that medication? Man, you keep interrupting.
I'm sorry.
You said you haven't been taking any medications. When's the last time you took a medication then, other than accidentally taking this amphetamine back on May the 19th?
I just stopped taking my medications last month.
Well, that's subsequent to May 19th, right?
No.
It's after May 19th, right? May 19th was 2 months ago.
Yeah, I stopped taking it last month because.
I know, so that was after you tested on this one. After you took.
That way it wouldn't happen again. I can't have that happening.
What do you go up to just pill bottles and start taking them? I mean, come on. I've heard enough of this.
No, I understand.
I can't get you straight. I don't know who you're kidding. I'm going to accept the plea. You're responsible for knowing what's going inside of your body. I don't know what to do with you anymore, Ms. Barton. Mr. Kerman, what would you like to say?
I really, just that this was over 2 months ago, no subsequent violation allegations since then. I think she has been making a concerted effort. With a bipolar condition, I believe, how medication affects that, I think is definitely a factor here.
I'm shocked. I've only sent her to, am I right that I've only sent her to jail once for 3 days?
You sent her to jail twice, once for 3 days and then the other time for 3 days.
Any thoughts?
I feel like we've gone around and around with Kelly. She'll do well for a while and then we have some issues again. Since the warrant was called, she wasn't warrant status. She did continue testing. She's tested June 4th negative, June 16th she was negative, July 7th she was negative. She's set to be discharged September 7th of this year, Your Honor. Only thing left for her is the money. Everything else she's done that was ordered, community service, court work program, she's completed.
How much does she owe?
$240, I believe, when I looked this morning, unless she's paid since then.
I don't get
You what?
240.
paid this weekend.
We haven't done too well for you. Either that or you haven't tried hard enough, maybe a combination thereof. I mean, come on. I don't understand why you're looking me in the eye and telling me these things. I mean, please. I'm gonna go a lot easier when people are honest with me. I don't like people lying to me. This is not, you're not pulling one over me. You can insist you accidentally took this. You didn't accidentally take this. You didn't. I don't know why you stand there and tell me this. I mean, I feel sorry for you. You got an addiction. I guess we should have got her in this. Did we try to get her in the sobriety court or anything?
I don't believe so, Your Honor.
Yeah, it's our fault. Can I see the screening?
Yes, Your Honor.
I mean, you seem like a very nice lady. Yeah, I mean, there were just not enough red flags at the time, but it's become apparent over time that she's got a serious problem. She scored a category 2 on the alcohol and 3 on the drug use. It's not exactly like this was screaming sobriety court. No, she had no established criminal history. She had a .172 on the breathalyzer, blood draw.
Judge, and she was ordered the alcohol education class originally. After her violations, you did order her to then do IOP. So she didn't even score high enough originally for treatment. It was later that you amended it for treatment.
Your Honor, in lieu of jail, would you consider ordering further treatment? You push out probation a little bit and see how she does?
We can't, I don't think. When did I place her on probation? Oh, February 24. Did you attend treatment? Where are we with that?
She completed treatment, Your Honor.
I believe the balance is 280 now.
I show a balance of 240, Judge.
Okay, maybe there's another payment that isn't reflected on the ROA. You can't pay that today, right?
I can pay this weekend. I can pay it Monday.
I don't know what else to tell you. I'm not gonna have probation keep chasing you. I'm gonna keep you on probation. I'm not extending probation. You're to serve 7 days or 10 days jail forthwith. Good luck. Have a seat, ma'am. I've tried everything I can with you. You're not helping us help you. There's nothing I can do anymore. I'm sorry. Good luck. Wayne, Mike, Mr. Rogers, get your lawyer in here, please. People against Wilson, Quentin, Lamar Wilson Jr., 2B, 141924A and B. Your name, sir?
Quentin Wilson Jr.
Give me 1 second until your lawyer comes in, will you please? Oh boy, I didn't realize it was Mr. Crawford. Why don't you have a seat? You have anything else ready, Mr. Carmen?
I'm looking for Robert Thornton.
Didn't I already take care of that?
Yes.
All right, recalling Quentin Lamar Wilson Jr., 22B141924B. And
Morning, Your Honor, Michael Crawford, representing the
your name, sir?
Quentin Wilson Jr.
I also have 22B141924A, so I have a possession of drugs, resist and obstruct. He's going to plead under height of the resist and obstruct. They're going to dismiss the possession of a controlled substance. True?
True.
Is that what you want to do? If you plead to that, I'll take it under height of the possible penalties are up to 500 fines, 90 days jail, costs are all those. I'll set terms and conditions of probation. If you're compliant at the end of that specified period, you'll come back. The case will be dismissed. You understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing nor a trial. Do you understand that?
Yes, sir.
The charge, resist and obstruct an officer, how do you plead?
Guilty.
On November 3 of 22, were you at 17815 Woodstock in Brownstown, 7:26 p.m.?
Yes.
What did you do that makes you guilty of this offense?
The contract. So that's the top, we all for
All right. So they got a call. They were investigating you on a drug charge. Is that true?
No.
It's my understanding that initially the stop was because they were on private property. It was like a cul-de-sac subdivision. And they investigated for that reason, and then upon making the scene, they investigated on that basis.
And then they ran.
Correct.
Is that true?
I'm not sure that's exactly how it went. When they got to the scene, I didn't have anything on me, so they found the leads in the car after they got us.
But they did tell you not to run anywhere or to stay there, correct?
Yes.
And you ran?
Yes.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it. I'll take it under height. I don't need a pre-sentence report, but I want to review this. I'm dismissing the drug charge pursuant to stipulation. I'm setting a sentence date, no PSI needed. I'll have you back here and I'll sentence you at a later time whenever Mr. Crawford is here again, okay?
Yes, sir.
So the other charge is dismissed, no PSI. I need a sentence date. Make sure the police report's in there, please. What do you have for me, Lisa?
August 6th at 8:30.
Okay, so you have to come back August the 6th at 8:30. Do you understand that?
Yes, sir.
All right. Any questions?
No, sir.
Who's this, your sister?
This is not.
Oh, okay. Okay, I didn't know. Nice. Pardon? Nice of you to come with him. He seems like a nice kid. He's got to stay out of trouble.
For sure.
Stay out of trouble. You're going to stay out of trouble, all right?
Of course.
All right. We'll see you back August 6th. Have a good day. Good luck.
Thank you.
I'm Michael Rogers, 25W8388658A and B.
Good morning, Your Honor, Michael Crawford, representing the defendant.
Name?
Wayne Michael
He's
Rogers.
going to plead to allowing an unlicensed driver to drive, and then they're going to dismiss, correct me if I'm wrong, the suspended equipment violation. True?
True, Your Honor.
Is that what you want to do?
Yes.
Are you sure?
Yes.
If you plead guilty to allowing an unlicensed driver to drive. Good afternoon, Detective. Good morning, I should say. If you plead guilty here to this charge, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. I'll then dismiss the suspended equipment violation. Do you understand that?
Yes,
This is 0 points. It won't go on your record. Do you understand that?
yes.
Did you sign, read, and understand the advice of rights?
Yes.
You plead guilty. You'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a 2007 Chevy that was being operated on West Road near Ford Lane in Woodhaven,
Yes.
May the 29 to 25?
Yes.
Did you allow somebody to drive that was unlicensed, and was that somebody you?
That was me.
Are you on probation or parole?
No.
He has a valid license now, right?
Yes,
Yes.
correct.
Anybody force you to plead guilty?
No.
Please accept it to that charge. The suspend and equipment violation are both dismissed. Anything, counsel?
Your Honor, as the court has already noted, my client doesn't need to be a valid driver's license to fix the defective equipment. It's a matter of course. He's a working man. He's taking care of his senior dad. He's in the senior citizen home, trying to bring him home right now. He's a responsible member of this community. He won't do this again. It just needs a payment arrangement because he's got a lot more on support his dad.
Okay, anything else, sir?
No.
100 fines, 70 costs, 75 victims' rights fee, $50 justice assessment, $40 in attorney fees. Your total's $315. $315 or 60 days. Does he have anything today, Mr. Crawford?
Yes, Your Honor, my client does have a portion today, Your Honor. He can play $200 today. He's asking to pay $100 a week starting July 31st.
I'm sorry, it's $335, right? 170, 295. Yes, $335 or 60 days. You said he can pay $200 now?
$200 today, and then get $100 a week starting July 31st.
I'll just make it $50 a week starting July the 31st. You'll only have a balance of $135, okay?
Okay.
So you're gonna pay $200 now, and then every week you pay $50 starting July 31, which is a week from Monday. And then after that, we should be all set. I'm sorry, it's a week from Thursday.
Yes.
Okay? I wish you well. If you need more time, call the court. We'll go on Zoom. I'll give you an extension, okay?
All right.
Best of luck. Alexandria Wolf, 25W839121.
Hello,
Your name?
Alexandra Wolf.
Ma'am, I don't want to be they want me to dismiss this. I think. No, they don't. Well, he didn't say anything about this. Can you call in Mr. Urick? What did he tell you?
He said he would ask for a 60-day adjournment to revisit this in 60 days to see how Sophia is doing.
Okay, good enough. There was nothing on it. He wrote on the bottom. I assumed he was moving to dismiss, but my apologies. So let me see what he says. Good morning again, Mr. Urick. Your name?
Good morning, Your Honor. May it please the court, William Urick on behalf of the city of Woodhaven.
So, did you want me to adjourn this, or what did you want?
I was indicating a 60-day adjournment.
Okay, because you didn't write it on here. That's fine.
Perhaps I slipped,
That's okay.
I got two disposition sheets going, Judge, apparently.
I got it. I get it. We're gonna adjourn this to mid-September, Lisa, okay? Is that all right, Mr. Urick?
Yes, Your Honor, what I was trying to do is get a full month of September in to see that everything's on the square with the youngster and that she's matriculating over in Pennsylvania.
Okay, give me the last part of September, Lisa.
Correct.
You have September 17th or October 1st.
October 1's fine if the court.
I'm fine with that. October 1st at
8:30.
At 8:30. I'm gonna have to set for trial if no other.
Understood.
No disposition, okay? So it's so good to see you here. Thanks.
It is fine to be back.
Good. Ma'am, I'm adjourning this to October 1, okay?
Okay.
You can zoom in again. I'm gonna give you a personal bond of $500. You can leave the state to go to Pennsylvania, okay? So you can stay in Pennsylvania. You cannot violate a law. You must appear in court as directed. And I'll see you here October 1, okay, ma'am?
Okay, would it be the same Zoom meeting number?
Yeah, you're stuck with me. Good luck. We'll see you October 1. Thank you.
Mr. Griggs.
Maya Latrice Street, 25W838853. And and then I also have 25W839217. Your name? Ms. Street, you're charged with driving on a suspended, 2 counts, 2 different dates. You have the right to a lawyer if you want one. You want a lawyer? I'm sorry, excuse me, jeez. Okay, we'll give you a lawyer.
Mr. Griggs, can you join the breakout room?
So you can go out in the hallway and he will set you up, okay? Noah Ryan Lore, 25W839130A and B.
Mr. Crawford's.
Is Mr. Crawford your lawyer? Yeah. All right, I'm gonna have to wait so you can have a seat, all right?
Is that gonna be discussion?
Sure. So this one is going to go to whoever you want to do it.
Do you want to do the outro, Judge?
Go ahead, man. Do 'em.
Mr. Griggs, do you see it on the screen?
No, it hasn't came up yet.
Okay, let me move it again.
Shawnee Transportation,
Here we go. It just came up.
25W388176. He's playing games here with me. 5,000, 10%. He's the president of the corporation. Call him. Tell him I'm setting 7,500, 10%. I don't appreciate this. Call owner. Tell him he better get in here tomorrow. We're going to issue that warrant against him individually, $750 will be the bond. People against Asian Madlock, Asian Harris Madlock, 5W838906A and B. Defendant failed to appear on the A file. We're issuing a show cause. On the B file, we're entering a default judgment. Paula Patricia Edmonds, 25W890778 and B, same thing, we'll issue a show cause on the misdemeanor A file and default judgment on the B file. Jackson Moore Walmsley, 25W838945A and B. Again, on the A file, he didn't show up for show cause, so I'm issuing a warrant on that. Second miss, 3,000, 10%. And on the B file, a default judgment was previously entered against him on July the 9. People against Demetrius Damon Earl, 25W837608. Then failed to appear. We'll issue a show cause versus that defendant. And then Norman Eugene Batten, Jr., 25W839-101A and B. Defendant failed to appear. These are both set for arraignments. We'll issue show causes on these. On the A file, the B file, and then on our Ariana Monet Coley, 25W83685. Then failed to appear. We are going to issue a show cause on that one. People against Laura. Noah, Ryan, Laura. So get that window over there. Just maybe Carmen can do it. 25W839-1308. Good morning.
Michael Croft, representing the defendant, association.
So I'm entering that guilty plea. He wants an adjournment, $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll take a date. Lisa, he wants to get a license, so we can give him 4 weeks.
August 20th at 8:45.
Okay?
August 20th at 8:45.
All right, sir. That's what I'll do for you. Good luck. Thanks a lot.
What was the name on that one, Judge? Sorry.
What's that?
What was the name on that one?
It's Noah Ryan Lore, Lore, out of Wood. Ma'am, you already met with the prosecutor, didn't you?
No, I did not.
Have you met with a lawyer?
I met the attorney when I turned myself in at the prior court hearing. I don't see him.
What's your name?
It's Michelle Zanatti.
Yeah. What is that up for?
I should found belonging to Mr. Foster, basically.
Well, that gentleman who was just in front of me, he should be representing you. The gentleman here?
Oh, it was a different man that I met, so.
Well, yeah, go talk to him.
Did you check in with John?
What's that?
Did you check in with John?
Did you check in with my court officer?
I did, and then he took, the one at the desk?
No, the one in here that's.
I did. That gentleman told me to come in and hand these papers, but he told me to sit down, so.
Okay, well, go find that Mr. Crawford there and you
Okay.
tell him who you are, and I told you to come and see him.
Okay.
Okay?
All right, thank you.
Sure.
I'll take this, and that's all we've got.
You want this one to go to Tony?
Whoever's got more time. We shouldn't have more than a couple left. All right, stay seated, everyone. Guess there's nobody in here. Oh.
They get to 30 minutes. Go ahead.
Thank you, Your Honor. Mr. Dixon, that card, Mr. Laird. Hello. I've never set out to commit a murder, but what you've seen, I don't think is the way you go about doing it. At home with your kids, they've eaten their pizza, they're in bed, you're asleep, you get a call from your niece, car trouble. You go help her out, find out what it is, get the car towed or pushed, go riding around looking for something to eat. Run into a guy you know that needs a ride home, his nephew or his brother, someone's left him stranded. You take him home, you're back at the scene, walking around, talking to people. Mr. Eckhart showed the video yesterday making a big thing out about who Mr. Dixon and this other fellow he was with, who we don't know, looking around and talking with each other and staring out in the parking lot. There were dozens of people out there walking around, talking to each other, looking in different directions. Nothing he did there was unique. They're all out there at 4 o'clock in the morning because they're young people and that's their lifestyle. No one knows what started all this. We think we know. We think it was over a woman. It could have been over something else or a slight. We just know it ended terribly. And I appreciated the state's witness, Miss Thomas and Jordan Whittington. They said they didn't know what was wrong with Ramon that night. Didn't know why he was being dismissive or not getting along or not engaging with Mr. Dixon. But pretty soon a fight erupts. And I didn't realize till yesterday, watching it, that with the enhancement and the brightening, that Mr. Dixon fought back a little better than I thought he did. He got a few blows in. I didn't realize that till yesterday, which is when Jordan jumped in, the guy with no shirt, and they are beating him on the ground. And if you need to watch it again, I know you will if you need to. And they were kicking him on the ground. Ramon's timber or whatever those boots were, those light colored boots, he was being kicked in the head. You don't see it real clearly. It's next to Crystal Thomas's car. I couldn't believe his medical workers weren't worse. He had a broken nose and a through leg, a shot through and through in the leg. I thought he'd look much worse. But at least 3 or 4 hours later, he didn't look. I thought he looked worse. That ebbs down, it calms down for some reason. We don't know what they're saying. We can interpret their body language. But not long after that, Mr. Carrington shows up. Mr. Carrington shows up with this exhibit, number 153. this exhibit right here with this extender holding, I think, 30 shots. Evidence shows he turns it over to someone. Apparently that's how it goes. You got the weapon, you turn it over, you're gonna fight for a while, someone holds it for you, you get it back later. So then it's Carrington, Ramond, and Jordan on him. That's the second fight. That one's a little obscure. There's an SUV that makes it hard to see the fight. You see the wailing and the arms and the hands, but you don't, or I couldn't see Mr. Dixon down on the ground again. That's the same weapon that Mr. Carrington pointed at Mr. Dixon's head about 5 minutes later. When that second fight calmed down, they're in that man's yard. It's off camera. It's in between what you've seen on camera 4 and in the alley on camera 16. He's in that yard with, I think, 4 people, maybe more. Ramon's in that yard. Chucky, who y'all have heard that name a lot, he's in that yard. Gregory Carrington's in that yard. And a big guy, maybe Mr. Prince, or maybe just a big fellow that was unidentified, is in that yard. Mr. Dixon has Chucky pinned down, and Carrington puts that gun to his head and says, "Let him go." At this time, he's already missing his keys. He thinks he's missing his keys. His testimony is he's missing his keys. His pants are down when he's in that man's yard before the man comes out and tells them all to get out of there before he shoots them. And he loses his wallet, and he loses his phone. He doesn't lose his pistol. I don't know whether he had his keys on him then or not. The police found those keys in his car, lying on the car driver's side seat. Who does that? Who leaves an unlocked car with their keys on a driver's side seat? Whoever put those keys there is the person that has his weapon. I have no evidence of that. That's me playing amateur detective. But whether or not he has his keys or not, has a gun to his head in that fella's yard. And then we're on camera 16 that you see ends up with the shooting. There's evidence, and it's in the charge, about intoxication. Mr. Dixon never says he was intoxicated. He says he was impaired. He says he was drinking. And I think he says drunk at one time when being questioned by the state. We do know a lot of drinking was going on out there. A lot of youth, a lot of drinking, a lot of people, a lot of guns. That's a bad combination. I don't know how dazed he was or how intoxicated he was. He'd been kicked in the head. I don't know. I don't think that's something you recover from in 10 minutes. But he can't get his keys back, or he thinks he can't get his keys back. He can't get his possession. They tell him to take it out in blood. We fought. We want to fight some more, or we're going to shoot it out, or you're not leaving here. And they're not leaving. None of them are going to walk away from this. This charge talks about reasonable, prudent persons. I look down on no one. I criticize no one's lifestyle. But not everyone is a reasonable, prudent person like the Father knows best. These are wild, young men and women. If you retreat, you walk away from something like that, you're a weenie, you're shunned, you're a coward. I know it makes no sense, it's all bravado, but they're not us. They are not us. They're out there at 4 in the morning, armed, a lot of them heavily armed. He didn't shoot Ramon for fun. And I know Mr. Dixon wishes he'd stayed home that night. He shot Ramon because he's feared for his life for Ramon and Gregory Carrington, who'd held him at gunpoint. The state has to prove to you beyond a reasonable doubt that Mr. Dixon's actions were not in self-defense. If you can't decide that, when you deliberate, that's reasonable doubt. 12 of you, 12 different verdicts. 12 different people who watched all this. And if any of you can't decide this after deliberation, after a lot of deliberation, if you can't come up with a unanimous decision, and the judge will tell you, keep deliberating, exhaust all channels. After all that, if you can't decide, you haven't wasted your time. You've still engaged and obligated your jury service. I only say this because I've had people come up to me later and go, well, we just, they weren't going to budge, so we just, they were hard-headed, and I'm just tired of it. I want to get out of here. What would the case scenario been? Mr. Dixon, I think, is like a 33-year-old man. I wonder what would have happened or what the charge would have been if he's not 33. He was 63 or 68. He acted in self-defense from an assailant or two assailants, and I urge you to find him not guilty. And thank all of you for being here and hanging here with us through all this.
State Texan.
Morning, everyone. Thank you for being here. I'm really sorry that it spilled over into another week. Not that was anything that had to do with us, but just that it's. I think on behalf of all of us, that wasn't our hope. And obviously, sometimes these cases do spill over, and sometimes the defendant takes the stand, and sometimes the defendant takes the stand and he lies, and we have to go and kind of comb through that and look and see what inconsistencies or what things are true and not true from that testimony, and if we're able to try and present you some evidence to show that he was wrong with his lies. So we've got a lot to talk about. We got a lot to cover. I am going to walk you through the self-defense instructions that the court has given you, just so you can kind of understand what you're dealing with here. Because really, in jury selection, we talked a lot about really just, I asked you to mostly focus on two things, whether he actually believed that it was immediately necessary to use deadly force to protect himself from someone else's unlawful or use or attempted use of unlawful deadly force. And then two is whether that belief was reasonable. Well, there's a lot of other, small moving parts to self-defense. But unfortunately, in these kind of situations, a lot of times the issue does have to be raised. And you never really know from our perspective, because we don't get discovery from the defense. We have no idea what they're going to do or if they're going to call witnesses or anything like that. So a lot of times it's a guessing game, and sometimes we're able to guess pretty accurately. But it always does depend on what evidence is ultimately raised. And in this case, they are raising this issue of this other threat, Gregory Carrington, and that being the reason that they're contending he was justified in killing Raymond Whittington. So there's a few other things that come into play, but what you'll notice is that they all kind of come back to those two core issues. So focusing on those throughout the trial and just whether or not this makes sense, whether or not it adds up, whether it's reasonable, that'll always ultimately get you to the kind of in the sphere of the right answer. Because I think the way I look at self-defense from a more, I guess, big picture perspective is I think that a lot of times it really does. You can you look and see whether it passes the eye test. And a lot of the law and the instructions that you get more or less are attempting to reflect that in one way or another. And so let me show you what I'm talking about. So this is what your charge looks like, okay? There's one page, and it's got instructions, and usually the way Judge Stevens does these charges is there's going to be one definition or one topic per page. So one page is going to address one issue or one application of that issue, and then the next page or next group of pages are going to address the next thing that you'll need to understand. And so if we go, you'll see that it's got just very simple outline of instructions, and it gives you definitions for an offense like murder. And obviously, I can blow these up for you, but you're going to have these. And ultimately, you're going to have to pick a foreman. What I suggest, especially in a case like this, where you may want to refer to the charge several times while you're talking, just to make sure that what y'all are talking about is correctly applying the law. I always suggest pick a foreman that is willing to make sure to kind of keep the group on task with what it says in that charge. Make sure that we're looking and reading this and then discussing whatever y'all think is pertinent about that. So we keep going. You got definitions like intentionally, knowingly, deadly weapon. That's in our indictment. Firearm is a deadly weapon. Obviously, we see in the video he shoots firearm. So some of these things are very simple, not going to be that controversial at all. Okay, so here's one that we hadn't really talked too much about because it's kind of it's pretty simple definition, and what you'll see how it's actually used in another definition, which is used in another definition, and ultimately kind of helps get to like what deadly force is. That's ultimately what all this is about, right? So just kind of be thinking ahead of time about distinguishing what bodily injury is versus serious bodily injury, because there's a big difference between those two. And serious bodily injury or death are what is the prerequisite for deadly force. Remember, we talked during jury selection about, well, there's more of a general self-defense statute that just talks about use of unlawful or use of force to protect yourself against someone else's unlawful use of force. But what we're dealing with in this case is actually that plus the next statute right after that, which is deadly force to protect against someone else's unlawful deadly force. You can only use deadly force, meaning he can only shoot Raymond Whittington if he was under threat from someone else's unlawful deadly force. So, and then here's our definition for serious bodily injury. And I'm going to get into these a little bit more and kind of talk to you about, what evidence I think is maybe helpful for you on these types of issues. But I just want you to kind of see what you're looking at here. You'll notice that it says means bodily injury, and then it goes and expands further. So it's incorporating that definition from bodily injury that we just went into. So that's why they kind of build on each other, right? Firearm, that's another definition that was going to be pretty obvious. And then here we get to our self-defense instructions. So this is the first one. I'll tell you that based on everything they've argued, this one really doesn't apply at all. Because what this involves is it's giving you a lot of the general instructions about self-defense involving deadly force to protect against deadly force by another. But it's not the multiple assailants. So the ultimate issue for this particular application is whether the person who deadly force was used against, meaning Raymond Whittington, whether that person was using or attempting to use unlawful deadly force. I think everybody at this point is in agreement that at the time Jeremy Dixon shot Raymond Whittington, that Raymond Whittington didn't have a gun, wasn't attempting to use unlawful deadly force. He might have been trying to use force, but not unlawful deadly force. So the issue then becomes what Jeremy Dixon testified about. He is talking about Greg Carrington from coming behind Pooh and his belief that Greg Carrington had a gun. That's what this is coming down to, really. But this instruction right here is still very important because it's going to give you a lot of the information that you need for your next instructions. It's also going to give you the information about what reasonable belief is and things like that. So you still got definitions and things like that that you would be applying. And it also reminds you that it is our burden to prove one of the two things. And what I mean by that is this is application of law and facts to self-defense. It says to decide the issue of self-defense, you must determine whether the state has proved beyond a reasonable doubt one of the two following elements. So why do we only technically have to prove one? I think both are proven here. But why do we only have to prove one? Because in order for the killing of Raymond Whittington to be justified, it has to be Jeremy Dixon had to have believed his conduct was immediately necessary to protect himself against Raymond Whittington's use or attempted use of unlawful deadly force, or with the multiple assailant, which we'll talk about, Gregory Carrington. And for it to be justified, that belief has to be reasonable. So if either one of those, if we prove to you that it was not reasonable or that he didn't actually believe that, then it's not self-defense. The other thing that this instruction is important information that it provides you, you don't have to agree on which one it is. You might say, I just don't believe what he did was reasonable. I don't believe that he thought that belief that he had that was reasonable. I don't think an ordinary prudent person would believe that he was in fear for his life, like Jeremy Dixon claims. Whereas you might believe, I don't think he thought that at all. I think he was lying about the whole thing. Or I think that he thought something totally different. Or like Dorian Price said on the stand, I think he was mad. He was mad about what happened over in the side yard. So if you both agree that one of those elements is established, that we've proven one of those elements, then it's not self-defense. Because in order for it to be justified, both have to be true, meaning I didn't prove either one. Also, we have deadly force, which I'll get into that definition in a minute. But here's the next one that I want to point out to you. Failure to retreat. That's not something that we talk a lot about during jury selection, but it's one of those like what I was talking about earlier. It's kind of it's part of that eye test rule, and you know it when you see it. Failure to retreat, what these instructions explain is that if someone is in a situation where they are faced with having to use deadly force or believe they're faced with using deadly force, it becomes incumbent on them to try and get themselves out of this situation. And there's only a certain set of facts or certain circumstance where they don't have to retreat before their deadly force would be justified being used. And what the law says is that there's actually a couple of very easy ways to determine whether or not someone failed to retreat. One, if they had the right to be present at that location, meaning they weren't trespassing or something like that, and they did not provoke the other person, meaning the person that they killed, Raymond Whittington, they didn't provoke that person. That's why we spent a lot of time looking at the earlier fight. Because believe it or not, I mean, obviously the earlier fight is all part of that night, but there's no deadly force used in that earlier fight. There's nothing to support self-defense from that earlier fight. It really all comes down to what he says he believed in that alley in the second altercation. But whether or not that earlier fight, whether or not we are able to determine from that Jeremy Dixon did anything to provoke Raymond Whittington. And then the other part, that the person is not engaged in criminal activity at the time deadly force is used. Which is why if you find that he did not provoke Raymond Whittington, and you find that he was not engaged in criminal activity, then you don't consider whether he failed to retreat. But if there's evidence, if we show you beyond a reasonable doubt that he did provoke, or that he was engaged in criminal activity, if one of those is true beyond a reasonable doubt, then you consider whether he failed to retreat as part of whether or not his belief was reasonable. That's what it applies to. It helps inform you on that second prong of our test, whether it was reasonable. And that's where this comes in. Unlawful carrying of a weapon. You notice I asked the detective about that right at the end yesterday. Because carrying a handgun while intoxicated is a crime, Class A misdemeanor. And it makes sense because why would that be a crime? Oh yeah, to prevent situations like this from happening. Now, here is the real crux of their self-defense argument is, I'm sorry, we just looked at this one. It's this right here. It's so you've got this application paragraph, and then you have a self-defense charge, which also is informative and kind of restates so that you understand exactly what you're needing to be considering. Then you get to this next instruction, which is multiple assailants. And ultimately, I think this paragraph right here is helpful to kind of give you the basic rule of law, is that when the proof at trial is clear that an attack being conducted by multiple people as a group, the defendant is justified in using force against any member of the group, even if the recipient of that force is not engaged in conduct that would alone justify the use of force or deadly force. So what does that mean? Well, it means that there could, if there were multiple assailants and they were conducting an attack as a group, that if one of those had a reasonable threat of deadly force to Jeremy Dixon, that he could potentially use deadly force in self-defense against anyone in that group. Now we'll look at this closer, and we'll kind of take a look at why this is not true in this case. But you get to the application paragraph or application instruction for self-defense as to multiple assailants, and you'll see that it's kind of similarly situated as the previous application instruction that we just went over. And you'll see that we're still considering the same things, just a little bit different. And so I highlighted the one that's different for you, and it's 1B. So 1, that's the same element prong that we are considering in any self-defense inquiry. Defendant did not believe his conduct was immediately necessary to protect himself. We have to prove that to you. Either that, or we have to prove that his belief was not reason. And then 1A, that's a really more or less a restatement of the previous self-defense instruction, because it's talking about Raymond Whittington's use of unlawful deadly force as being the threat. But B is what describes the multiple assailant aspect of this instruction. Right? Immediately necessary to protect himself against B, Gregory Carrington's use or attempted use of unlawful deadly force. I may have a wrong version of that. It should say deadly there, I think.
It's use or deadly force, use of force or deadly force, as the case may be.
I see. Okay. And the previous instruction paragraph for that actually says that exactly. So I mean, it's obviously it's very clear that this deadly force can only be used when faced with the use or attempted use of unlawful deadly force. There is no exception to that or situation where it can be some other type of force. It has to be unlawful deadly force. But what you'll see is that it has that second part there, that if Raymond Whittington and Gregory Carrington were both present and acting together to attack the defendant. That's the difference. That's the difference between self-defense from a threat of unlawful deadly force from Raymond Whittington, and self-defense from a threat of unlawful deadly force from a group of people, any individual of that group threatening with deadly force. Okay. And that belief still has to be reasonable. And then this is just your final charge. If you're answering that we have proven to you at least one of those elements of self-defense, meaning that he did not actually believe that it was immediately necessary to use deadly force, being Jeremy did not believe that, or that belief wasn't reasonable. If we've proven one of those to you, then you would find him guilty of murder. Okay. What I want to talk to you about is looking at some of the things he said. Because at the end of the day, a lot of this comes down to what he testified to, what he said at the hospital. He's the one who's saying that he was in fear of his life. Okay, so as we kind of talked about this, let's just go through the timeline of that night. So according to Jeremy, 2 a.m. he gets this call. And he goes to help out a friend. I don't know that I believe anything he says, to be honest. But there are some things that we can verify, and we know either they happened in the video or that there's some other way to independently kind of corroborate that. But he says he goes to help his niece. Well, the witness that testified for him yesterday said he called him or texted him 7 different times wanting him to come out that night. Well, Jeremy says he had no intentions of going out that night. He was looking for food. Again, both these things, a lot of the things that he said don't really jive together. But regardless, we get closer to 3 a.m. and that's when the video begins at the S&S grocery. By this point, Jeremy has explained that he has finished with what he was doing over with his niece and was headed over towards the B&B shack across the road. And after they had their parking lot full, he goes over to S&S Grocery. Ends up at S&S Grocery sometime around 3:30. 3:55 a.m. That's the first time we see him on the video in State's Exhibit 1. All right, now I'm going to show you all this and just explain to you one thing. I know it feels like everything I've been doing is very tedious. My goal in these types of cases, especially where there's something that you really got to look closely at on the video, or something that you've got to see clearly and closely. I try to show it to you as many times as possible so you're sick of seeing it. Because ultimately, it's easier for us to all look at it together out here. And you feel like you've seen it enough where you don't necessarily even need to see it anymore back there. But if you do want to see it back there, I just want to show you what the exhibit looks like so you know how to navigate what we're going through. Just remind me. So you've got camera A16. That's the alleyway camera, right? That's where we see the shooter. You've got camera A4. That's the front parking lot. Okay, so when we go into those, y'all remember I keep saying when I'm playing on the video, I'm playing the last file in that folder. And the reason I say that is so we make a clear record of where everything is. That file right there, the big one, as far as this house. That's the one that captures the fight in the front parking lot. That's the one that captures Jeremy Dixon walking up at 3:55 a.m. It captures everything all the way to the point that they're going off to the right and going into the other camera. And then if we go back into the folder for camera A16, we go all the way down to the bottom, the file ending in 1054. The very last one. That's the one that captures Raymond and Jeremy Dixon walking across the towards Concord Road, and then few minutes later, coming back, and all the way up to the point that he shoots and kills Raymond. Okay. So we're about 3:58 right there. And we've already seen Jeremy Dixon for a few minutes. He's over there. So 3:55, he shows up. 4:02 a.m., he's walking across that parking lot. By 4:03, he and Raymond are already arguing. We watched yesterday and we saw that kind of interaction with them at first, where Jeremy seems to be antagonizing him at first. And then Raymond, I don't know how to describe it. It's like he was kind of cowering away. Like he didn't want to have this interaction at all. And he didn't want to be around it. It's unusual. And we'll look at it here again in just a second. But very quickly, Raymond, his posture changes, his demeanor changes. No doubt, when it comes to the fight, Raymond was in the wrong. So was his brother. And you know what? Technically, so was Chet. But that's not why this is relevant. Why this is relevant is because we're trying to decide whether 15, 20 minutes later, Jeremy Dixon believed that it was immediately necessary for him to kill Raymond Whittington in self-defense, and whether that belief was reasonable. Well, part of the reasonableness inquiry that we make is whether or not he failed to retreat, meaning whether or not he could have left. That makes this very important. Because one of the things that we look at and one of the things we ask, and when we're looking at whether someone could have left and should have left, is whether or not they provoked. And that's what we see here. We see Jeremy Dixon going out there and provoke. We see multiple times where he could have easily left, but he didn't. And he claims that they had my keys. Chucky stole my keys. No. We don't even know if his car was unlocked. He may have locked his keys in his car. We don't know. There was blood on the handle. And so they didn't try and open it. Now we know that's Jeremy Dixon's blood based on everything we saw from the layout of the shell casings and all of that. But he did say that he went to his car. And he did say that he couldn't get in. And then lo and behold, he's claiming on the call yesterday we listened to that, well, who had my keys with the blue hook in my pocket, in the pocket. I was trying to get them back. They promised me they would give them back, and then they did. Either he's wrong and just making something up, or he's outright lying. Neither one of those bodes very well for him on this issue, right? He went out there and provoked him. Now they're arguing. By 4:10 a.m., they're fighting. 4:12 a.m., we see that Dodge Durango, the Dodge SUV, that pulls up, and right before that SUV pulled up, we see as it's pulling into the parking lot, we see Gregory Carrington get out of that car and walk alongside of those cars towards the group. That Durango, we'll later see, is driven by this person named Jay Fox. We see him later pass the gun to Gregory Carrington. He has the gun and gives it to him. I'll show you. 4:12, that car pulls up. 4:13 a.m. Now Gregory Carrington is fighting with Jeremy Dixon and Jordan Whittington. Jordan Whittington and Jeremy Dixon started to get argumentative with each other, and Gregory Carrington, we see him go over and almost immediately get into that fight. Okay. 4:16 a.m. By this point, they have moved all the way over to that side lot. We see him go. Raymond Whittington keeps backing Jeremy Dixon up. But Jeremy Dixon's still in a fighting stance. He's not trying to back down. He's not trying to back down. So that's nonsense. That he says that he's didn't want to fight or he didn't like. He went out there and he clearly wanted to fight. It's just the truth. Side lot, they're at 4:16. I think in like 50 seconds, they're in that side lot. By 4:18, they are already back. We're talking about, depending on the seconds, somewhere between 2 and maybe 2.5 or 3 minutes. That window right there is what Jeremy Dixon wants us to believe forms the basis for why he then killed Raymond Whittington 4 minutes later. That's what he wants us to believe. Okay. 4:19 a.m. They're back arguing. Jeremy Dixon has already walked away and then come back. And I mean, he walked away to get back, to continue this argument. 4:20 a.m. and 50 seconds. That is when he shoots Raymond Whittington. 4:23 a.m. Carolyn Lewis testified yesterday. There's an abandoned 911 call from Jeremy's phone. So the only reason this came up was because he said something about that when he testified. So I asked Carolyn to look into it. She's the top person over at dispatch. She would know. So she looks into it, and there's an abandoned call from his phone. But then I thought to myself, but I thought he didn't have his phone. Because Octavia said that she ended up with it later. And at this point, Jeremy's already saying that they took his phone over at that side lot. So if his phone wasn't passcode protected, which I think most people's are, or even face recognition, then maybe Octavia opened it up and tried to call it from 911 from that number. That doesn't seem as likely to me as maybe Jeremy still had his phone and he was lying about them taking it over there. I don't know. And ultimately, I don't think it matters because everything that we've been told by Jeremy is just not true. And that's the problem, is that if everything that he tells us we have to take with a grain of salt because he's a compulsive liar, then I think the only option that we have is to go by the hard evidence that we know exists and see how it compares. And the video, the body language in that video just speaks volumes compared to what this man has told us. 4:23 a.m., abandoned 911 call. 5 a.m., sleeping, and I have a question mark. He says, when he testified, that he went through the gate, behind that fence, and ended up just falling asleep back there behind that fence. And then magically, he gets up and he goes to the clerk at Supermax store, a few blocks up, and tells him to call police because he wants to tell police his story. The man was sleeping right behind the place where you could hear police. They were there all morning long because that scene was so chaotic. Because remember, 95% of the police force, the on-call police force, had to come there. I think we all kind of know that this is a violent place, that our community is violent. I talk to a lot of people, family members of cases where I ask them, so has it always been like this? No. But even though I think we know, when you see something like this video here, where you see a man walking on the sidewalk with an assault rifle, and you see people openly carrying guns and not running away from a shooting, but walking towards it, it just paints a vivid picture for you that I don't think anybody really understands about the place where we live. 7:50 a.m. Jeremy Dixon is located by the dumpster. No record of a 911 call from the clerk of that store. We have these witnesses: Octavia Charles, Dorian Price, Crystal Thomas, and then we also have Jeremy's brother, Jordan Whittington. To me, I think the ones that are the most credible to you are Octavia and Crystal. And the reason I say that is because you see in the video, right up here, when they start fighting, Octavia gets up and walks away. She is not having any of it. And she said she was stone cold sober. She just came there to get her car. Crystal, same thing. You can see when things start to get confrontational between Jeremy and Raymond, you can see a Crystal on the video pulling it, saying, no, don't do that. I mean, it's just clear. And they say that, I don't know, they describe it by like that motion. It's it's an unusual thing to describe. But they say that when Jeremy came up, he just started hitting Raymond like this, right here. And he's just asking, you good, bro? You good, bro? I don't think they really knew that there was this conflict at the time. But we see it on the video. We see him. He keeps reaching his hand out to the man. That is provocation. Now, I will tell you that when it comes to self-defense, provocation, there's two different ways of considering provocation. In the failure to retreat, it is one thing. But verbal provocation is never enough to use deadly force in self-defense. What does that mean? Well, I can't say that I'm going to kill someone and that be justification for that person to then pull their gun out and shoot. Now, when I say I'm going to kill someone, that's a crime. That's called a terroristic threat. But it doesn't justify them shooting me in self-defense at that very moment. Not without some other context to it. Something else that a jury could rely on and sink their teeth in to know that that was an imminent threat. So here we go. There's your question. Self-defense question 1. And ultimately, this is what we just talked about. And we're going to end up closer to that second one. Did he believe his conduct was immediately necessary to protect himself if Raymond Whittington and Gregory Carrington were both present and acting together to attack Jeremy Dixon against Gregory Carrington's use or attempted use of unlawful deadly force? Now, first thing we know, Gregory Carrington, when Jeremy shot Raymond, Gregory Carrington did not have a gun. He didn't. We see him go to get one. And his conduct, what we're talking about is the shooting. Shooting Raymond. That's the conduct at issue. He says, you were in fear of Carrington. This is Jeremy's testimony. You were in fear of Carrington. Yes. You shot Pooh. Yes. That first one, it's out. That's just fear from deadly force used by Raymond Whittington. He didn't use deadly force. He didn't have a gun. There's no evidence to suggest. And like I just said, provocation. There's two different situations where whether or not someone was provoked that you consider it as self-defense. The first one being verbal provocation, meaning could I make a threat or say something that would justify someone else shooting me in self-defense, killing me in self-defense. It can never be enough on its own, ever. But failing to retreat, one of the two things that you consider is whether or not the person who acted or is alleging they acted in self-defense, whether or not they were committing a crime at the time, and whether or not they provoked the person they shot. That is why this becomes pertinent. That is why all the times that in the other camera that Jeremy Dixon goes back and then walks away and then goes back and is on the camera arguing and has this very hostile body language. That's why all of that is very important, because it is very clear that he was continuing to provoke Raymond Whittington. And Raymond Whittington never posed a threat to kill him.
Judge, I hate to object to close, but that's a misstatement of evidence.
Sir?
I hate to interrupt Sonny's close, but that is a misstatement of evidence.
All right. Your objection is overruled. The jury gets to decide what the evidence is from their perception. They get to decide how much weight and credibility it deserves. You've already made your argument, and you can be seated.
Thank you.
He's entitled to make his arguments, and the jury is intelligent enough. I trust them. They will recall the evidence and apply the law as appropriate. Please proceed. Thank you.
And there's such a huge difference in what Jeremy Dixon says on August 6, 2023 to those detectives and what he said on the stand when he testified here in this trial. Complete and total opposite. And he says, oh, I mean, he gave the simplest explanation. Oh, I'm a compulsive liar when I'm drinking or when I'm drunk. Even compulsive liars don't lie about things that would disadvantage them and get them in more trouble. His compulsive lie would convict him of murder. Compulsive liars lie to get out of trouble, as do most people if they're going to lie. But he says things that I don't know how you can take back. Like the other people didn't have guns. Pooh didn't have a gun. Jordan didn't have a gun. He says, I went back to my car. Then he comes here and says he never did. I just don't know how he can expect us to believe him when he walks it back that far. It just makes it so that nothing he says is believable. But I tell you what is believable, his body language on the video. So did he actually believe shooting Raymond was immediately necessary to protect against the use or attempted use of unlawful deadly force? Remember, this is our definition for deadly force. Force that is intended or known by the person using it to cause death or serious bodily injury. And that's in our instructions. Or force that in the manner of its use or intended use is capable of causing death or serious bodily injury. All right, so intended deadly force. You're talking about shooting someone, stabbing someone with a knife. There's this other way, deadly force in its manner of use, like maybe a car accident where there's some criminal element to it. Well, that could be deadly force as well. It's not what we have here. We have shooting. But I'll tell you what's not deadly force. All of the fighting that we see. Kicking him, it's not deadly force. There's not serious bodily injury. And how do we know that? Well, aside from the fact that he has no bruises, no injuries, we have medical records. Put him in evidence. We'll go through them and I'll show you. There's no evidence whatsoever of serious bodily injury. He was checked in at the hospital at 8:30 that morning, and he was already discharged by 11. Serious bodily injury. That's part of our deadly force definition, right? Bodily injury that creates a substantial risk of death or that causes death. Then it also has these other different ways. I will tell you that none of them seem to have any application here, but serious permanent disfigurement, meaning you've lost, an arm, or you have some permanent injury that causes, facial deformities, something that can never be changed, or some sort of internal impairment or protracted loss of like an internal organ. Like a case I had a long time ago where a kid was hurt and had liver malfunction, almost died because of an adult hit them and perforated their liver. Okay. None of that really seems to apply. So really, it's all about substantial risk of death or causes death. Nothing about that fight implicates that in any way whatsoever. Only deadly force at issue, according to Germany. Whether we believe this or not that's your call. The only deadly force at issue is the guns. And the only gun that he could point to is the one that he claims was held to his head. And even that, I will tell you, doesn't justify self-defense, because he could have shot him over there on the sidewalk when he actually had the gun being held to his head. But the man didn't have a gun when Jeremy basically shot and killed Raymond. Gregory Garrett didn't have a gun. At the hospital, he had CT exams, imaging of all of his different body parts, because it had been reported to the doctors that he had been in a fight, that he had been shot. They were going to do a head-to-toe exam. What we have, CT of the head, facial bones, and his cervical spine. Meaning we're going to look to see if he has any long-term injuries from this fight. Because I will tell you that I looked at the video and I don't see him getting kicked in the face. I see him getting kicked in the side, and I see him getting kicked in the butt. And getting kicked by two drunk people. Here's the findings. Minimally impacted nasal bone fracture. A broken nose is never serious bodily injury. No acute intracranial abnormality, meaning no head injuries. Minimally displaced nasal bone fracture. No acute fracture or malalignment of the cervical spine. We get through all these other, I'm not going to go through all of this, but general appearance. No apparent distress. Resting comfortable. I mean, the man was discharged in 2 hours with a gunshot wound because it was through and through. They patched it up and he's good to go. They did a head-to-toe physical exam and imaging of his head, his abdomen, all of his extremities, and his neurological function. Everything was fine. He had a partially black eye. Maybe after a few days, it became a more, distinguished black eye, but a black eye is not serious bodily injury. There's nothing to suggest that he was ever faced with serious bodily injury from that fight. Denies blurry vision, denies redness, vision change, denies bleeding gums, everything. And these records are in evidence, so if you really, want to reassure yourself that I'm not, trying to hoodwink you or anything, you can look at them. 10:50 a.m. That's when he's released. The on-call trauma surgeon has come down to see and evaluate the patient. He has examined the patient. He agrees with the plan of care. Patient will be discharged home with a diagnosis of alcohol abuse, assault, GSW, gunshot wound, and a broken nose. I will discharge patient home on antibiotics given broken nose, as well as multiple GSWs. trauma surgeon actually recommended against closing these wounds. So he didn't even want to close them up. They weren't actively bleeding because the wound in the thigh and in the tibial region, meaning the entrance wound and the exit. Then they say, what's his diagnosis? Gunshot to the right thigh, and there's no injury to the bone or vascular structures. Has a non-displaced nasal fracture that requires no intervention, and he's diagnosed with alcohol use. Why did they say that? Because he appeared intoxicated. So why does he claim that someone had used or attempted to use deadly force against him? All stems from Gregory Carrington and that gun. But the problem is that he isn't even consistent with his own version of this. He keeps saying things like, I never knew what people's intentions were. I never knew exactly who had the gun or what was going on. That is not enough. The point behind that is it is not reasonable. The belief that he had is not reasonable. And frankly, I don't think he actually believed it at all. So when was the gun put to your head? When I was on my knees after they pulled my pants down. And who put the gun to your head? It was Carrington. So Carrington had a weapon. Yes, sir. Did you have a weapon? Yes, sir. And then this is me asking him a question. And he's explaining something else, but he said, every time I seem to defend myself and fighting back, someone else jumped in. Then when I tried to fight harder, someone else jumps in. I think that's true. We see that in the video. So I gave up on fighting back. That's not true. We don't see that in the video. The last time I tried to fight back, Carrington put a gun to my head and told me, let the man go. Because I was holding Chucky by his arm. So now, the only specific instance where he is able to describe someone else threatening the use of a firearm against him, not even using or attempting to use, just threatening, is when he had that little guy, Chucky, and he was holding it. And Carrington, according to Jeremy, put a gun to his head and said, let him go. Is that really, even if we believe that to be true, which I don't think it is, but even if we believe that to be true, that isn't enough. Threatening to use a firearm is not enough. Verbal provocation alone is not enough to justify self-defense. And we know Carrington did not have a firearm when Jeremy shot. Do you actually believe it was immediately necessary? We'll look at the failure to retreat on whether it was reasonable, but he had so many options if he just would have left. That's the problem with this whole thing, is that he had so many chances to leave, and every single time he chose to go back. He made that choice. He continued to argue. He continued to provoke them. Even though there were multiple people that were very hostile towards him, multiple people that had put him on the ground and were hitting him, he still wanted to go back. And now, as it turns out, his keys weren't there. Nobody had his keys. They were in his car. Probably because he had been drinking, and he had been drinking long before he admitted to drinking, and he forgot. Or maybe he's just straight up lying and he knew exactly where they were.
Time to close. Thank you.
Was his belief reasonable? This is the part. He says, did Carrington have a gun? Because it's not just that the gun was pointed at him, according to Jeremy, over in that side lot. That alone doesn't give him a reasonable belief. That alone is not a use or attempted use. What he says is that I feared that Gregory Carrington had gotten the gun from Chuck. And when Raymond approached Jeremy for that last time, right before he was shot, we see Gregory Carrington casually walking back towards the same direction as Raymond. And what Jeremy is trying to tell us is that he believed that Gregory Carrington had a gun and that Gregory Carrington was going to use it, even though he has no prior situation between him and Gregory Carrington, where Gregory Carrington actually suggested that he was going to use the gun. He told him to let the man go. That's very different than threatening to shoot. But he says, that's the guy. He was J. Fox. That's the guy Carrington kept passing his gun off to. Like every time he got ready to come hit me, he'd pass it off and come hit me. First of all, why are they passing guns off? Well, because they're all wearing really baggy pants and their guns fall out when they're fighting. And they're not going to fight with a gun because people at this location know that's really stupid. That's how you get shot. And then he says, it was Pooh, down like the bottom says, it was Pooh kept passing his gun off to Chucky, and Carrington kept passing his off to J. Fox. J. Fox is the guy that was driving that Dodge SUV. He's the one that we see right over here in the video, later down the line, give that's J. Fox right there in the black. He's the one that we see give Jeremy the gun. Or give Gregory Carrington the gun. Right there. You see him? You see how his little shirt's poking out right there? That's the gun. We watch very closely. He comes from in this general direction, but he's out in that blob of people that appear to kind of peer around that corner into the side lot and then come right back. Gregory Carrington, we watched him yesterday. He goes over to that side lot for less than a minute. And he wants us to believe that in that time, he made a credible threat that made him fear for his life 3 minutes later. As Gregory Carrington is sitting there, pulling his shirt up, sweating, and letting his belly fat hang. And then we get to the shooting happens, and this guy, the guy with the gun, he's looking the other way. He's kind of peering back around the corner. That's J. Fox. There's the gun, see it? Right there on the left. They're messing around with something else. They have no concern about the fight that Jeremy and Raymond are having. Yeah, they run. Now what does he do? He runs over here, and looky there. There's old Greg Carrington. Because his buddy was just shot right in front of his face, and he didn't have a gun. And he goes, they go right to each other. Now look, he calls out his name, and he slows down and stops, and he passes it off right there. Boop, right there.
Have we approached him?
What do you need?
I told myself I would object after an hour.
Okay, object.
It's been an hour and.
Okay, please wrap up.
Well, it's been 10 days and I'm trying to.
Hold on. Each party gets a reasonable amount of time, and that's what each party is entitled to. But wrap up.
Oh.
Thank you.
Passes the gun. He didn't have one. He says, Pooh kept passing his gun off to Chucky. Carrington kept passing his gun off to J. Fox. That's true. But then what does he say? What does he say when he says why he was afraid for his life? Right at the moment he shot Raymond. He says, so, see, look up at the top left corner before he comes towards you. Go back. He's talking about Carrington right there. He says, you see, that's Chucky standing right there on the corner. Like I said, he kept switching his guns out with Chucky, talking about Carrington. See, he leaves from Chucky and then he comes towards me. I said, right before that, he had said, the only one I'm thinking still has one, meaning a gun, is Carrington. At that moment, did you think that that Carrington had a gun that still has his gun is Carrington? He says, I asked him, I said, do you believe that so you're saying you believe he might have a gun? He said, I believe he had one on him at that moment. I asked him, so why would you go back? Because he wasn't afraid. He had a gun. And he said, so I could be seen on camera. You want to be seen on camera where you murdered a person in cold blood. I wanted to be seen on camera just in case they did try to shoot me. After they just made that threat, they would. You cannot possibly expect us to leave. So like I said, switching out guns with Chuck. Carriage. He never said that before. In fact, he's getting his lies mixed up. It was Pooh that kept passing his gun off to Chucky, according to him, even though we have no other evidence at all to suggest that Pooh had a gun. And that's Jeremy saying Carrington passes his to J Fox. And we see it right there. So, where does that leave us? He didn't really believe that he was acting in self-defense. He didn't really believe that it was immediately necessary to shoot Raymond. I don't know what his exact reasoning for doing it was. Maybe it's exactly as Dorian said, that he was mad. Maybe it's that he had been fighting. Maybe it's that they weren't really fighting about something that happened 8 years before, and they were fighting about something totally different. But I know he went up there and provoked that man, and I know that they fought because of it, and I know that after they were done fighting, he provoked that man again, he walked back up to him, he kept walking back up to him. And then, the very second Raymond goes to hit him one more time, he's already has his hand in his pocket, he's already got his hands on that gun, and he's already pulling it out, or in the process. So that when he spins around, he puts 4 shots right into his chest. And I will tell you that yesterday I asked about what they thought he was doing as Jeremy was walking this sidewalk over. He reaches in his pocket and he's fidgeting with it. Maybe he was making sure that his gun was there, that the safety was off, or that it was properly, positioned so that he could pull it out, because he knew that he was going to go over there and start some sort of conflict, or that there was going to be some sort of conflict. Because he didn't go over there, talk to his buddy in the car. He never even spoke to him. He went over and talked to every single other person but Riley Barnes in that car. Not only that, but Jeremy Dixon was engaged in criminal activity. He was intoxicated. The medical records actually show. Not only did he say, medical records show, now this does not equate to the same thing as blood alcohol content like what you would expect in court, but it does show that he has ethanol in his blood. Doctors, that's the initial comments. Look at that very third to last line. He appears somewhat intoxicated. This is hours later. There's just too much that he's lied about. he didn't actually believe he needed to do this to defend himself. He did it because he wanted to. And even if you believe that he actually believed that, it wasn't reasonable. Doing it wasn't reasonable. Could have left. Those people would have never followed him, tracked him like he says. All he had to do was stop arguing, stop fighting, and walk away. And he chose to kill him instead. Convicted of murder. All right, ladies and gentlemen of the jury. The parties have rested their cases, presented closing arguments. The court has the jury charge. I'm going to tender it to the bailiff at this time. Please follow the bailiff into the deliberation room. We will await your verdict. It is obviously 12:30. Think seriously about breaking for lunch. But it's your choice. You decide what you want to do, how long you want to stay before you break for lunch. But it's always a good time, just make sure that you're focused and alert. Let the court know we will work at your request. Thank you. Everyone else remains seated while the jury exits. All right, we are in recess. Thank you.
No.
You're good. You're good. Stay seated.
All right, I'll let them know. I'll see you then.
Henry.
Okay.
Destiny, Danye, Henry, 25W837-840. We're gonna issue a show cause. Jeremy, Kristen Antoni Roberts, 25W837-064. Failed to appear for the initial hearing, will issue a show cause. Paul Edward Pelchat. 25F243439, defendant failed to appear 525. Cash assured failed to appear for show cause. Rayvale E. Booker, 20B 138496B, 25B 1447399 A and B. Warrants to issue bonds to be forfeited 302 cash assurity on 496B. 201 cash assurity on 399A and 375 cash assurity on file B. People against Ballard Jackson, Michelle Shanique Ballard Jackson, 24B144935. Defendant failed to appear, $55 cash or surety. Algeron Wright, 25B148108A, 213 cash or surety. 282 cash or surety on 108B on Mr. Wright. Pham Nagak, Tien Pham, 25B147796. B, that's 282 cash or surety. Christopher Eugene Moore Jr., 25B148010B, 282 cash or surety. Sean Malik Lavender, 25B148079B, 282 cash or surety, and file 25F243540237 cash or surety warrants issued.
He said he'll have everything ready in 15 minutes.
Well, I guess we're not going to get ahead. Okay.
Testing, testing.
Jessica Rose Shaft, 25W838765A and B. Defendant failed to appear. Issue a bench warrant, forfeit the bond, 4,010%. That's on 765B. Yeah, this is just a willful intent to delay adjudication. Defendant failed to appear. Bench warrant to issue. I'm gonna do 3,010% on the drunk driving and 3,010% on the B file. So it's gonna be 3,010% on each file. And then there's a default judgment on the C file that was entered or should be entered today. Let's go. People against Griggs, Aaron David Griggs, 23W8325565 A and B, Aaron Griggs.
Well, Your Honor, Mike Crawford representing Mr. Griggs. Mr. Griggs is at the county.
Mr. Griggs, your name?
I'm trying to move him out of the breakout room.
Okay.
There he is.
Mr. Griggs, your name?
Aaron David Griggs.
So this could be a plea on the B file to false information, and then the A file, drug paraphernalia, will be dismissed. True? True. Is that what you want to do? Is that what you want to do?
Yes.
If you plead guilty or the possible penalties or up to 100 fines, 90 days jail, costs or all those. Do you understand that?
Yes, Your Honor.
All right, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to question their witnesses. You have the right to a jury trial. If you plead guilty, you're giving up all those rights. There will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Charge false information to an officer. How do you plead?
I plead guilty, Your Honor.
Were you on West near Allen and Woodhaven, July 15 to 23 at 10:42 p.m.?
Yes, Your Honor.
Did you tell them your name was something other than Aaron Griggs? In other words, you tell them it was Aaron Michelle Campbell or Chamble?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
You're not on probation or parole right now, are you?
No, not right now, Your Honor.
Please accept that this drug paraphernalia is dismissed. What, anything?
Well, Your Honor, my client is asking for time served. He's been incarcerated since February 2025.
Shocking. Go ahead.
There's nothing else to add, Your Honor. He's looking forward to completing his debt to society and being released. He's got positive plans for his life, Your Honor. He does not plan to be before this court again.
What have you been incarcerated since February for, sir?
I was dealing with a case from Flat Rock and a case out of Wayne County.
Mr. Griggs, was that a retail fraud charge?
No, that was the first one from Wayne County was a GTA case that was dismissed. But I served 90 days on that. They gave me time served.
I'm just going to give you credit for time served. 100 fines, 200 costs, 75 victims' right, $50 justice assessment, 4 1/4, 6 days, credit 6. You're all set. We'll close the case. Good luck. Thank you.
Thank you, Your Honor.
People against Johnson, Dwayne Johnson. Dwayne Montiel, Alec Johnson, 25W838-974. A, B, and C, your name.
Good morning, Your Honor. Michael Crawford. Good afternoon, Your Honor. Michael Crawford representing Mr. Johnson.
Dwayne Johnson. You wait formal reading?
Yes, Your Honor.
He's now going to plead to allowing an unlicensed driver to drive with the suspend to be dismissed. He's going to plead responsible to impeding traffic on the speeding, and then the other charge, the no insurance, would be dismissed. True?
Yes, Your Honor.
Is that what you want to do? Sir?
I'm gonna plead responsible to impeding.
Is that what you want to do? Yes or no?
Yes.
And you're also going to plead guilty to allowing an unlicensed driver to drive, right?
Yes.
If you plead to that charge, allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail, costs or all those. If you plead on the impeding, that'll be 0 points. If you plead to that, I'm going to dismiss the suspend, speed, and no insurance. You understand that and agree to that?
Yes, Your Honor.
All right. Did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or trial. Do you understand that?
Yes, Your Honor.
The charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
On June 23 of 25, were you in control of a motor vehicle that was being operated in the city of Woodhaven, county of Wayne, on Hall near Van Horn?
Yes.
And you allowed somebody to drive that was unlicensed, and that was you, true?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty
No.
to the charge of impeding traffic, responsible or not?
Of it, and they took the rest off for community service work that I did at the Monday program.
Okay.
I've been working. We bought a new of it, but I'm seeing it's possible, you know.
What's your name, ma'am?
Erica
What's your last?
Johnson.
Erica Johnson? I don't like my girl. We'll call her Miss Johnson from now on.
Miss Johnson.
Yeah, I don't
Okay.
like it either.
That's all right. All right, so we're doing some tree work, right?
Yes, I'm in Brightview.
Okay.
Yep.
Officer Evans?
What's our take on all of this?
We were here in January, about 6 months ago. Mr. Fall had just been released from Monday. He immediately got involved with aftercare with Brightview. That seems to be going well. He's consistent with it. His job actually allows him to have that Tuesday off so that he can make those treatment appointments, which is huge. He has been making payments on some outstanding financial obligations that he had through other courts. He's always on time. He's always here showing up for his appointments. We've been out to the apartment. Everything seems to be going really well. He has a huge support system with Erica, who's able to get him to and from.
Let me just say, it's Miss Johnson.
Miss Johnson. Miss Johnson. With Miss Johnson, we're on a first name basis, but he's doing really well. So I just really wanted to set this review hearing to kind of give him a shout out for all the hard work that he has put in over the last 6 months and keeping his head on straight, staying away from old people and old places and doing what he needs to do. So it's been really good to see.
Sounds like we're crushing it so far.
Yeah.
All right. We're gonna set this for another review. What are we thinking? 90 days-ish?
That's exactly what I was going to say. Yes.
All right. Anything else you want to tell me, Mr. Fall?
No, that's it.
All right. We'll see you next time out. It was nice meeting you, Miss Johnson.
Thank you, Your Honor.
Thank you.
All right. Next we have Mr. Mann.
Cool. Cool. Bye, Ms. Johnson.
Hello, Mr. Mann.
How are you?
I'm okay. Tell me what's going on.
Since, I don't know if it's been a month or last month we were here. I did the DIP program. I did complete that.
How was that?
It's different. It was my third one, so it's
okay.
That was the charm. It's got more strict, which is
How
good.
so?
I mean, it's just like you get a room and they take the card down, they put tape on your door and all that because of whatever's going on.
Okay.
Yes. You're either in a conference room all weekend or outside smoking, and that's it.
Okay.
So it went well. I definitely realized that I didn't know everything about, certain things. I can't drink at all, but it's not really just 0.08, it's anything. It could be weed. Weed's legal now, but you can't get high and drive a car. Mine was alcohol. So I did complete that. Working 48 hours a week. Got a little promotion there at Booyah.
Okay. What are we doing for them now?
Utility manager.
Okay. That sounds interesting.
Kind of keep production going, so that's cool. I like to get in there and work, so I've worked less now, but it's starting to.
Utility manager?
Yeah, just keep production going on the whole plant, the coating process.
Okay.
Getting mainly my relationship with the big man better, and recovery communities come first, but that's getting better. It's not easy, but calling somebody and talk about problems, or just calling people in general, even though I used to call the dope man at 2 a.m. If I can do that, I can call sober people. So it's getting better.
I've never had it put quite that way, Mr. Mann. That is an interesting. way to
Trust
put it.
issues. I used to call people I didn't even know for stuff, that was destructive to me. But I don't know why. That kind of helped me be able to call people that I need help and staying sober. As far as trust,
So here's, what I'm going to say, Mr. Mann.
And I'm coming up with new and improved boxes.
What's that?
Coming up with new and improved boxes. I know I check them off all the time. I'm getting better boxes and making better decisions.
This is the point in we'll call it the John Mann cycle. This is the point in the John Mann cycle where frequently enters a bad influence, usually, as Mr. Fall would say, a girl. Bad influence that derails all of our progress that we've had so far.
Right.
I don't mean to run you down. You're doing a good job and things are going good. I am sort of excited about the promotion at work. I mean, there was a time not too long ago, last year, where we were celebrating you just having a car and having a job.
Right.
So now we've moved up to, we're celebrating promotions and that kind of stuff, which is good. We've talked about it probably 100 times before, so I'm not going to give you the Superman, Batman, whatever speech we're going to do. Although Superman movie is out, you should go see it.
I can't hear that.
Where are we at, Officer Evans?
Yes, Your Honor. Our main focus the last few months have been really that recovery community that he's been speaking of, which is him just reaching out for support when he needs it. He does work a lot of hours, but he has still made it a priority to make it to meetings and things like that on Saturdays. I think you have a Saturday morning meeting that you attend before you have to get on the bus and get to work. So that's huge. There are also some other people in his life that have years of sobriety who have kind of been down the same road he has that he can talk to, that he's been reaching out to if he needs to. So this is kind of, yes, 1 year ago was Deergate, as we call it, and he is aware of that, and he's making better choices and just reaching out to people that actually support him and have his best interests at heart. So we're working through that. I think one of the things that I was talking with Mr. Mann and his mother about was possibly like an incentive, like a trip that they were planning out of state, something like that, that I think would be good for him, just, you know, with his hard work and everything that he's done.
Where are we going?
Philadelphia.
Really?
City of brotherly love. Yeah.
Have you been to Philadelphia before? Do you have some contact with, why did we pick Philadelphia?
Just check out the different, there's like, she likes gardens and stuff and landscapes, and you got Rocky Balboa there.
You're gonna run up those steps? You think you got that in you?
I'm too old yet. I'm gonna hit the stairs.
They say it's tougher than
Twice. I'm gonna hit it twice.
they say it's tougher than you think.
Right, I might just walk it.
Okay.
But yeah,
All right.
You know, something out of town. I've been to Pittsburgh, but never Philadelphia. Somewhere close, but not, you know.
All right. What else you want to tell me today, Mr. Ma'am?
That's about it. Just that I'm making better decisions. I was last year. The year before that, it's getting progressively better.
Okay.
I still make a couple bad decisions, but not major. That could lead to eating a frozen pizza right before bed's not good, you know. For the most part, I'm making a lot better decisions.
Okay. Well, I hope you do take the trip to Philly. I hope that you are able to walk or run up the Rocky Steps. There is something from the Rocky character that, I mean, when you get there, if you do this, take a minute while you're standing in front of that big statue and think about probably one of the most important things that Rocky ever said, which is, it does not matter how hard you hit in this world. You know what I'm going to say next, right?
Right. Getting back up.
It's how hard you can get hit and get back up. That's his legacy. Hopefully that will be your legacy as well. All right. I'll see you next time out.
Thank you much, you know.
All right, Mr. York. How are you, Mr. York?
Fine, how are you?
I'm okay. I'm glad that the next person up was not some young punk who has never seen the Rocky movies. You've obviously seen all of them, right? All right. What do you want to tell me?
I'm just doing everything I'm supposed to do
Okay.
and keeping it as that.
Officer Evans, pretty short and sweet, but pretty much accurate, right?
It is accurate, yes. He is doing fantastic at Mindful Healing right now. Just an excellent report I received from them just a couple weeks ago that he is attending every session. He's participating in these sessions. He is actively working to develop these relapse prevention plan. He is working on his coping skills, building that support system, and he's drug testing. He's negative. It's just pretty awesome to see all of this in a space that he feels comfortable to. Because I know we were here last month and we were talking about the coach and how he immediately reached out and said, this isn't going to work for me. It's important to know that. But he's staying here with Mindful Healing and he's doing a great job. So really just, you know, React funds are helping pay for this, which I think is huge because without it, he wouldn't be in that spot. So I think he's taking full advantage of it, which is great. So I know we set these kind of back to back just to make sure that he hadn't fallen off and nothing negative was going on, and he's doing great. So Just continuing his treatment as is, attending his NAA meetings. I know he does 11 and 1 on Tuesdays, and he's going to traditions as well. So those are great sources of support for him. So probably see him again maybe in the next couple of months or so for a review.
Mr. York, I counted it up today. If we count the MAT reviews that we used to do back in 2016, this is the 24th of these types of hearings that we've had. I know that you are not one to really talk that much, and I get that. Seems like things are going well. So let's keep up the good work, and I'll see you next time out.
All right. Thank you.
Mr. Deaton,
Your Honor.
how are you, Mr. Deaton?
Good.
We've seen all the Rocky movies, right?
Yes, sir.
Okay, that's good. All right, so what do you want to tell me?
Been a star.
Tell me about Star.
Something special. It was good though. Learned a lot.
Like what?
Like not to act on impulse as much. It's a big habit. Like kind of prioritize a lot of things in my life. Kind of realize how much what I was doing was affecting everybody else, not just me, like my family and everybody. Just to take my time and think before I do anything, and how to recognize like risky situations and scenarios, stuff like that.
Okay, go ahead. What else besides the STAR program? What's going on with your life?
I'm going to groups 3 times a week at Define Recovery. I've been on lockdown, so I haven't been able to go look for a job yet, really.
When did we start our treatment?
When
did we or do we?
Last week I started.
Okay.
Groups.
All right. How's that going?
Good.
Officer Evans, where are we at with this?
So Mr. Deaton and I have not formally met just due to FTO and me being on leave. But I have been able to speak with him on the phone while he was at STAR, and with the help of Officer Torek and Miss Wilkerson, we've been able to kind of coordinate things for him. He did get put on lockdown with the intention of him getting involved in aftercare. So after the STAR program, there was nothing that was set up with the STAR program for his aftercare. And then we had a positive drug test for THC. So he was placed on lockdown due to that. He quickly then got involved with Recovery Defined. He has been there. They just sent me a progress report yesterday, and it looks like he has been compliant, attending his groups 3 days a week thus far. So at this point, what I'm looking at with this case is that I move him back to curfew status as long as he can be compliant with Recovery Defined in his IOP schedule, and then we'll keep him on the monitor until that THC leaves his system. So probably set this for another review in September.
What's up with the weed, Mr. Deaton?
Just anxiety and like cravings, and I know I shouldn't have done it, but I mean, it did help. It helps. I know I can't do it anymore. I stopped. They said if my levels don't keep going down, then they'll move me up to 5 days a week. So I don't really want to do that.
That is a very scary answer for me, Mr. Deaton. What part of that answer do you think scares me the most?
I don't know, sir.
I used it because I had cravings and my anxiety, and it seemed to work.
And with anxiety, really, with the cravings, just I don't want to do anything else.
I mean, here's the thing about ILC, Mr. Deaton. ILC is drug-free, so that means no weed.
Okay.
And you know, if you want to be one of these people that is like, I'm going to be sober except for the weed, we can have a nice philosophical debate about whether that's a thing or not.
I understand.
I will tell you it's not.
Yes, sir.
But there are some people who they have a baseline, and if they have some weed in their system, they can get through the day. I don't think that's the right attitude, because I think for somebody like you, the THC is a step in a direction that you don't want to go back to. So we just need to not do that. So I think there's a decent plan in place to make sure that that doesn't happen anymore. I'm satisfied with that plan. And is there anything else you want to tell me?
Just thank you, Star. Really did help. When I got there, it was a lot overwhelming at first, but as time goes on, it definitely gets better, and you see what it's there for.
Yeah, not everybody likes the STAR program, but I do.
Yeah, I like it too. Now.
Okay. All right, I'll see you next time out, Mr. Deaton.
Thank you, Your Honor. Have a good day.
Mr. Gross.
You can meet. Yeah.
Hello, Your Honor.
How's it going, Mr. Gross?
Pretty good.
Tell me what's happening.
Just still doing my program and looking for a job.
So what keeps us busy all day?
Just doing my chores at the apartment and going to NA, AA, and doing my group.
What meds are we on these days?
I'm on clonfazine for ADHD. I'm on Avelity for depression and anxiety, and trazodone.
We went through a period where we stopped taking it. What was that about?
Because I didn't feel any different that I was taking, like I didn't feel that it was working or anything. And then it was brought to my attention that, something was off. I wasn't, the same as I first got there. And I was like, I didn't know what was different about it. Then somebody was like, well, you quit taking your medicine, didn't you? Like, yeah. And they told me that I should have just, told the doctor, that I didn't feel, that it was working, and they could have upped my medicine, but I just up and quit taking it. But I've been taking it for about a month now.
Seems like we were off track, but we're a little bit back, right, Officer Evans?
That seems to be the case, yes. Mindful Healing did reach out at the beginning of this month with their concerns. He abruptly stopped taking his medications, and he was found taking someone else's medications. And there were some issues, maybe just leaving without submitting a pass and things like that. That type of behavior that ultimately was the reason he got kicked out of Mindful Healing a year ago. So we had that conversation, Mr. Gross and I, about although he didn't relapse, this is still that same type of behavior that can lead to that. So if he's feeling off, if he is, reaching out for help is the main thing. So whatever's going on, whether it's a case manager or counselor, he wants to call up probation, something to discuss that so that we can someone to discuss with so we can keep him on the right path. Since they put him on this behavior contract type 30-day thing, he has kicked it back into gear. And his focus is to make sure that he is attending those groups. He is following the rules there, so we don't have that same situation where he was a year ago. So I'd like to set him back here with us in September just to make sure that he hasn't fallen off again and that he is still forward focused. So.
Anything else you want to tell me, Mr. Gross?
No, sir.
So here's the thing, Mr. Gross, and it doesn't matter if you're on probation, ILC, supervision, post-release control, parole. It doesn't matter what you're on, what kind of supervision that you're on. The basic thought process needs to be, I am doing okay. When you're not doing okay, you have to recognize that and have somebody help you get back where you need to be.
Yeah.
And, I can't tell you how many people I have that are on probation with me and be like, well, why don't you just come? Why didn't you come to court? Or why didn't you do this? Well, I didn't want to, or I was afraid, or I didn't think I needed this. You need to make it part of your process to be like, oh, I'm having a bad day. Somebody needs to help me have a better day. If it's Officer Evans, if it's Ms. Wilkerson, if it's case manager, if it's a friend, whoever it is, you need to get back and you need to take your medications like you're supposed to, and you cannot be taking other people's medications. Yeah. That's not a thing. Okay? Mm-hmm. All right. I'll see you next time out.
All right. Thank you, sir.
Is that everybody for REACT reviews, right? Wait, who did we have? Your name? Oh, Mr. Bird. Yeah, I have him on the list. I don't know why I didn't call your name. Well, I know why I didn't call your name. It's because you're at the end. But all right. How are you, Mr. Bird?
I'm doing well. I completed an inpatient program with Sojourner around the 19th of last month, and then I started IOP with them. I'm doing 4 days a week, 2.5-hour groups, and that's going pretty well. I feel like all the counselors and stuff there have been saying I'm doing really well. Same with the inpatient, and doing everything I'm supposed to do. Started putting some job applications in this past week. I feel like
Who do we bring with us today?
My girlfriend and my sister.
Okay. Which is which?
Girlfriend.
Okay, what's your name, Aunt? We already established we don't just say that's my girl.
I'm Bridget Kaufman. I'm his sister.
Okay.
Kayla Marquardt is girlfriend.
Ms. Kaufman is the sister. Is
We
it
got a baby in the bun.
Marquardt? Right?
Yeah.
You know, most of the time when I do these reviews, nobody comes with these folks. You kind of see how it goes. They just come, show up. Does make a difference when you have somebody that comes with you. So good for you for coming out and supporting Mr. Bird. All right. What else you want to tell me?
I mean, as you can see, I've got a really good sober support system. I feel like I learned a lot through Sojourner. Mostly, I mean, really, it was mostly a refresher because I had a long time clean before. I've done IOP before. I felt like I relearned a lot of stuff and picked up some new things, and I just figured out, I need to lean on my sober support more when I'm feeling certain types of ways, not keep it to myself. I feel like everything's gonna go pretty well this time.
Officer Evans?
So normally it is a pretty big red flag when I have to file a violation before I've met somebody. But after his violation, we were talking about, what it would look like, what probation would look like, what his treatment looked like. And after he completed the residential program with Sojourner, his mindset seemed to change for the better. Also, I think it helps, his girlfriend is also pregnant, so he's focusing on that and making sure that he can stay successful. We've had conversations about periods of sobriety that he's had in the past. I think years of sobriety. So he's done this. He can do this. He is going to his IOP several days a week. He's been able to coordinate that on his own with the help of insurance and rides. It helps that his sister is such a huge support system for him as well, allowing him to live there, have a stable environment, a sober, supportive environment. And he really is taking this opportunity and running with it and seems to be doing a really good job. I've had no issues with his ankle monitor. He communicates with me about anything that's going on, or if he has to be out a little bit later, everything like that. So
How long has it been on?
It has been almost 60 days.
So it makes sense to take him off today while he's here?
That was what I was going to say. Yeah. I would like to remove him from the ankle monitor today and set another review here in about 60 days. So we can check just to make sure we're still on the right path. But
Okay. Anything else you want to tell me, Mr. Bird?
I just thank you for the opportunity, not just locking me up after my violation, giving me another chance at treatment. I know I can do this, and especially now that, like she said, I have that baby on the way. I don't want to be an absent father.
Yeah, don't thank me, Mr. Bird.
Thank you.
Thank you.
Officer Evans was
You.
bad for you, having never met you.
Yeah, she did.
That still doesn't make sense to me, even as I sit here today, but seems like she was right, at least so far.
Thank you, Ron.
Okay? All right, we'll see you next time out.
Thank you.
All your equipment and everything, they know you're coming off, so just head back down there. All right, cool. Yeah.